This is Circuit Court, Judge Davis Williams preside. Please bow your head for a moment of silence, please. You're bringing up seat. Sorry, we're starting a little late. We had a technical problem. Zoom, some things weren't operating right. Transport Alfred Crucius. Commonwealth versus Alfred Crucius. Commonwealth versus Alfred Casillas, 25 CR 0052 and 25 CR 0033. Are you Alfred Casillas?
Yes, sir.
Good morning. Were you born in 1985? Last four digits, social security number 5305. We're here today on pretrial conferences on those two cases. What does the Commonwealth have to say?
We have a felon employee that might record on that.
Okay. I've just been informed that a motion has been tendered that says you wish to enter plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol? So this is plea freely and voluntarily given.
Yes, sir.
Are you the same person that we just identified in 25 CR 0052 and 25 CR 0033?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Review the evidence Commonwealth has against you, feel like you're fully informed about your case.
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm gonna roll with it and I'm gonna ask if you understand, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at jury trial, right to confront and cross-examine all witnesses, call and testify against you. Right to produce evidence, or right to call witnesses yourself and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and have a right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. Understand that by entering this guilty plea today, you give up those rights. Do you understand that?
Yes, sir.
Okay, now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided. Well, I don't have to accept the recommendation. Prior to accepting any recommendation, I'll wait the report of the pre-sentence investigation report done by probation and parole. After reviewing that report, if I decide to impose a harsher sentence and reject Commonwealth's recommendation, you have a right to withdraw your plea of guilty and proceed to trial. Do you understand that? If you step to your left a little bit, please. Mr. Stockton, what is the Commonwealth's recommendation?
Your Honor, upon a plea of guilty to possession of a firearm by a convicted felon, and possession of a controlled substance first degree, he'll receive 2 years on each charge to run concurrently for a total of 2 years. He'll also plead guilty to DUI and receive a $200 fine and cost. This 2-year sentence shall run consecutive to the to Cumberland Circuit Court Case 25 CR 33 for a total of 7 years to serve. The Commonwealth will oppose probation. All the firearms listed in the Commonwealth's offer will be disposed of in accordance with laws of the Commonwealth of Kentucky, and the defendant will pay court costs at the discretion of the court.
What kind of firearms did he have?
Well, he had a black semi-automatic pistol, a 9mm, and he also had a magazine with 9mm rounds in it. 2 pistols.
Is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
Doing so of your own free will?
Yes, sir.
Knowing your constitutional rights explained to us is still your desire to give up those rights, enter a guilty plea, and allow the court to fix your punishment.
Sir.
You understand that by entering a guilty plea, any future conviction will enhance the range of penalty and a persistent felony offender law. Now, is that your signature on the document?
Yes, sir.
I'll accept the agreement for now, order a pre-sentence investigation report and schedule a sentencing hearing. Sentencing hearing shall be on November the 10th. But I'm telling you now, I'm gonna closely scrutinize these firearm things. I'm tired of convicted felons having firearms, especially these automatic weapons and things. So we'll have a more discussion on that when we meet, after we look at the pre-sentence investigation. Great. Thank you very much.
Thank you.
Bobby Garman. Commonwealth versus Bobby Garman, 25 CR 0051. Are you Bobby Garman?
Yes, sir.
Good morning. Were you born in 2001? Last four-digit social security number 1566. We're here on a pretrial conference. What does the Commonwealth have to say?
Your Honor, Mr. Garman has multiple cases pending in other jurisdictions, and I don't know if the DPA attorney wants to have another, Mr. President, another
Yeah.
pretrial conference.
You have one more negotiation.
What is?
He says it's
What is
November the 14th at 9 a.m.
November 14th here at 9 a.m. Your next court date. Well, the next court date here is November 10th.
Well, November 20th, I thought it's 20th.
Oh, I gave him the wrong date. Yeah, excuse me, the 20th. I was looking at district court list there.
Okay.
November 20th. 14th and the 20th are your two. What other jurisdictions do you think?
There's Graves County and where else?
In Metcalf, I believe.
Okay.
What's he charged with here?
Well, they're all theft by deceptions, taking money and failing to do construction work.
Yeah.
All
Okay.
kinds.
Okay, we'll see you then. Thomas O'Donnell. Commonwealth versus Thomas O'Donnell. Let's see. You Thomas O'Donnell?
Yes, sir.
Good morning. Born in 1963, last four digits, social security number 6773. There's a motion and limits. You may proceed.
Which motion are you taking up?
Whichever one you want to.
Okay, I filed the motion for ruling on the motion previously heard that was taken under submission in August. And that's just asking the court.
Is that on the instructions?
No, Your Honor, it's about whether or not we're gonna trifurcate into three
That's the
payments.
instructions.
Okay,
That's where you trifurcate or bifurcate in the instructions, isn't it? Am I right? I mean, is there some other issue than on whether we,
no, that's the issue.
what does the Commonwealth have to say about that?
Well, Your Honor, it's always been my understanding since the Rainier standard came out that you had to bifurcate, have a guilt innocence phase and then a penalty phase. I could not find anything directly on point as regards aggravating circumstances in a murder case that you have to trifurcate or bifurcate.
As we were looking at that, my staff lawyer was looking at, we had some, post-traumatic syndrome, remembrance of a case we'd done like that.
Well, that was the Bryant
That was
case
the
in
Bryant
Monroe
case.
County.
And the court didn't say we were wrong on the thing. It just said it hadn't been preserved.
That's correct.
But, the issue on that one was we gave an instruction trifurcating and had them sign where someone was a persistent felony offender first, and then went to the trial stage, and they said it should all be done at once. And you're wanting to trifurcate this time.
Yes,
Okay,
Judge.
now I can't. And so the trifurcation in your situation is you want the jury to decide whether aggravating circumstances before they go down. But I don't see any authority that you presented. The case that you had was a weapons case, right?
Yes, Judge, the court, last time we were here, actually, the Commonwealth was in agreement with our motion to trifurcate, and the court asked me to produce
Yeah,
any case law where a trifurcation
didn't.
wasn't reversed.
I don't think you did present anything.
Well, I stated on the record, and I will repeat that Mr. Stockton is correct that there's not case law specific to the aggravating circumstance being done in that way. But there are cases such as the one I submitted to the court where there has been trifurcation and that has been upheld. So it's not unheard of. The parties were, as far as I know, in agreement to proceed that way, and we were just waiting, Judge, on your
So
ultimate.
the Commonwealth, I mean, if the Commonwealth's in agreement.
Yeah.
You're in agreement?
Yeah, I
Okay, now
always,
I want to get your client specifically on record about this, okay? And I don't want to, Mr. Donnell, I want you to be careful. If you don't understand exactly what I'm saying, stand away and talk to your counsel, so you won't say anything to incriminate yourself. But do you understand what they're asking?
Yes, sir.
Okay, and you're in accord with that?
Yes.
Okay, well, I'll go ahead and we'll do that. No problem.
And I hope DPA, next time I want to trifurcate a PFO case, they're in agreement.
Well, I don't really,
I don't think that,
I can see how it could cut both ways.
Yeah.
I can see how it could cut both ways, especially if you feel like you're in a situation where you might have a client that there's no sympathy with in the public or something. I'm not saying that's the case here, but you'd be afraid that they would use those to try to enhance the penalty rather than to make a separate finding. And I do think that there's situations where findings could be advantageous or not advantageous. So if everybody's in agreement, who am I to stand in between that? So now you have any other motions?
No, Judge, that's all we had on today.
Okay, thank you. We don't have a trial date yet, do we?
We don't, Your Honor.
Well, since we're all here together, where are we at on that?
Your Honor, since the trial was continued, I've been trying to get a geolocational data report from Elizabeth Wheeler. She's the specialist from the FBI. And we had a conference call with her, and Miss Detective Burton has just now submitted all the information to her, because evidently it's an arduous process. She has to go through peer review, and when she does it, she wants to do it all at once. So it may be a month or two before we get that back. So I wanted you all to be aware in case you all had an expert on it.
Well, yes, we need to review the report before we know if we need to have an expert to testify to
Oh, that's-
cross-examine.
That's ridiculous that you will actually review the report, be informed about it. I
Yes.
don't know what.
And Judge,
Okay, well, I'll just wait till you guys get everything lined up.
Yeah.
But we've got some space available, so once everybody gets lined up, and if y'all have an expert, and if that expert wants to look at it, that sort of thing, you need to, move it along, because Mr. O'Donnell's been held for quite a while. Nobody's filed a speedy trial thing on him yet or anything, but I mean, I think that he deserves a trial, and the victims, families,
If you want to set a trial for next spring or April or May or something, that might be good. And that way I can start to domesticate my subpoenas.
January is better.
too cold around here, Mr. O'Donnell, in January for these people to get out,
Because I've got all these out-of-state witnesses I'm gonna have to
okay,
procure.
well, let's just get our calendar out and take a look at something. Let's look at in April 27th through May the 1st.
They file, right?
And then I will keep, I'll keep the 4th and 5th open in case we go into the second week. And I will just tell everybody, I'm inclined to try it that week, whether everybody's ready or not.
I want to get it over with, just like Mr. O'Donnell does, Judge.
Judge, there was one other discovery issue that we wanted to revisit from our August date.
Wait just a second. Okay, what do you have?
Your Honor, when we were here in August, the Commonwealth indicated that we had a motion on about whether or not Detective Burton is allowed to testify regarding the cell phone data, the interpretation of that data. The Commonwealth at that time indicated that they intend to try to produce, I guess, qualifications that would show that Detective Burton is an expert in cell phone data interpretation. And I believe the court,
Well, he can, I think what I said, is he could do foundational testimony.
yes, but the Commonwealth wants him to do more than that. And I
How do you know
believe
that?
they stated that in August and they were to produce
I don't
his
remember.
credentials.
I don't remember saying that foundational.
Well, I did state that, but then the judge said he would be able to talk about the case and put it in context and do foundational type. And I thought that'd be sufficient. I probably didn't reply to that when we were having our argument.
So you are,
He won't be able to testify as to the truthfulness or validity of any information. But I'm not going to handcuff the Commonwealth to not be able to give an overview or to place things in context to be supplemented by the expert testimony. And if the expert testimony is not sufficient, then I will instruct the jury to disregard that. But there's no way that you can do an overview of a case without him being able to say what they did, who they got, what the results appear to be at the time. And you'll hear, ladies and gentlemen, jury, you'll hear testimony about that later as far as, to be able to establish the validity or how you use it in making your decision. But we're not gonna have little peephole sort of things here. There's gonna be an overview by the detective who will establish things, and then they'll have to establish each one of those elements. And if they fail to do so, I'm sure you'll not miss the opportunity to call to the jury's attention that they did not live up to what they said they were gonna do in the statement of the prosecuting officer. This is not your first rodeo or my first rodeo or Mr. Stockton's first rodeo. We're gonna have a fair trial for Mr. O'Connell. We're gonna follow the rules of evidence, but I'm not gonna get so hyper technical that and I'm not saying y'all are gonna do it, but I have tried cases where it appeared the entire case was almost an entrapment to try to get the court to make rulings that would overturn any kind of ultimate thing. So I'm gonna protect the record and your client's rights and the Commonwealth's rights. But I just wanna make sure that we give the jury an opportunity to get the full flavor of the situation, give you an opportunity to cross-examine anybody. And I think the system will work, will allow it to, okay?
well, Judge, if the Commonwealth's agreeing that Detective Burton is not going to be presented as an expert, then I'd ask the court to grant.
I'm not
Motion we
gonna, because sometime between now and then, they might decide they need for him to be an expert witness in something. And then if they do, they'll have to present testimony sufficient to establish it. As a matter of fact, I've seen people established as expert witnesses on the stand at trial. So I mean, I'm not going to handcuff them at this stage on what their witnesses might or might not say. You know what the results from the expert witnesses are, or you will know before then. So we'll address that issue later. I don't see how this damages your preparation whatsoever. If I thought it damaged your preparation, I'd make a ruling on it, but I'm not going to say that they can't qualify him. As of now, he is not qualified as an expert witness.
So, Your Honor, would the court like me to file a separate motion asking for his?
I don't care what, you can
Detective
file whatever you want to.
qualifications? Well, Judge, we addressed it on the record in August and it.
Well,
was to be
I'm telling you
produced.
what the ruling is now. Okay, the ruling is as of now, he is not an expert witness and shall not testify as an expert witness. But I'm not going to say that he won't ever be qualified as an expert witness. I just want to give you notice to the fact that because I rule it based on the information I have now, that there could be a subsequent necessity or proof that he is an expert witness. And if that happens, we'll deal with that then.
Okay, so
Okay.
Judge, I
I
just want to be clear. You're
Well, you
denying
got it on
my
the record. I'm
request.
telling you, as of now, they have not presented him as an expert witness. And he has not been qualified as an expert witness.
I understand, Judge. What I'm asking is for an order that the Commonwealth produce his credentials so that we can review them.
If
Because
they,
he's
if
going
they
to be-
decide to call him as an expert witness, they can do
I
that.
think we've already produced these credentials, if not, we will.
That's fine. Okay, thank y'all very much.
Your Honor, there is one other issue.
You know what string betting is? You ever played any poker?
No.
Okay, well, a string bet, when you put a little bet out there to see what somebody's reaction is, and if you think they don't want it, you do another one. So I've asked you 3 times if there's another one, but we'll do as many as you want to. What is your next, what's your third one?
Your Honor, we had an evidentiary hearing scheduled for Mr. O'Donnell related to the violation of the attorney-client privilege issue at the jail. That had to be canceled because he was at KCPC. We would just ask for a new date now that he's back.
Well, I would like to know, one, the parameters, what we're having hearing over and what the potential remedy is, because this is a matter between Mr. O'Donnell and the jail. There's not been any prejudicial evidence gleaned from anyone against him in this case. And I just.
Well,
don't know
the
what we're doing.
Commonwealth, I think previously stated that they haven't received anything from any of the jail, any information. Is that correct?
When I furnished.
Is that correct?
That's
Is that
correct. I
correct?
furnished the reports to the defendants.
Okay, well, what's the issue then?
Judge, this hearing was originally established in order to make a record in terms of the facts underlying this violation, so that the court could then determine the prejudice to the defense and any remedies available. So this is
Since
just,
then, and just now, the Commonwealth has said that they have not received. So what I'll do is sign an order that says if at any time the Commonwealth receives any information directly or indirectly about any violation of potential rights that the defendant had to privacy in the jail, that they shall immediately notify the defense and we'll have a hearing on it.
or Judge, we know that the violation did in fact occur, so.
Do you know the Commonwealth has been told anything about it?
Yes, sorry. Yes, Judge, there are employees from the jail who have been interviewed, who have.
They're what?
There are employees from the jail who have been interviewed by law enforcement who have admitted to going through these materials that were clearly marked as.
I'm asking if
materials.
the Commonwealth knows anything about it. The
Yes.
Commonwealth Attorney's Office has been informed about it.
Yes, Judge, because
Ms. Wall?
information coming from that notebook was communicated to the Commonwealth's attorney, so that this hearing is about.
What was?
After reading the reports, I don't know of anything that was communicated to the Commonwealth attorney that was accurate.
And Judge, that's why we need this hearing, so we can elicit
Well,
this.
what would be if your client's privacy rights or expectation of privacy, if he has one there, had been, what would be the remedy?
Judge, right now, our position is
What would
that
be the remedy?
it's striking the enhanced penalties based on how this situation unfolded. And that's why we're requesting this hearing to
How
lay
would
out
that, how would
that,
that have anything to do with the enhanced penalties?
because following this violation, the Commonwealth then filed a motion for enhanced penalties. And we believe it was due to information from the notebook that had been communicated. So this hearing is simply to lay an evidentiary record of what happened. And the court may ultimately find that there was no prejudice, but at a minimum, we need this hearing to establish what the prejudice was and how these events unfolded, resulting from the
It
violation.
was my recollection that
The problem with that theory is I originally filed for a death penalty in this case. And because the capital murder wasn't listed on the indictment, we had to go back and redo the indictment, which we did. And I held off filing for any enhanced penalties until we got closer to the trial date. And that's the only thing, the reason that was filed. But what I'm saying is, we made a record. The state police went and interviewed all these people that had access to this notebook at the jail. They filed reports, which I furnished in discovery. There is nothing in those reports that have anything to do with this case. Now, they did go through his notebook, but the Commonwealth did not glean any information that can be used against Mr. O'Donnell.
have
Nor
you
am I
looked at the
gonna use it.
notebooks?
They have them. I've never
Have
seen
you
them.
looked at the notebook?
Yes, Judge, and those notebooks include defense strategy discussions. And so again, that's why we need this hearing to at least at a minimum build this record in terms of who accessed these privileged materials and where that information
Or
was
if they were
disseminated.
privileged materials?
And they don't even want to turn the notebooks over for the court to review the notebooks. So how do we even know what's in it?
And Judge.
I'm not, well, I'm talking now, please let me finish. I don't even know what's in the notebooks, don't care what's in the notebooks. But they don't even want the court to see the notebook so you can make an informed ruling on it. So I don't know how you proceed in that instance.
Judge, my suggestion for how we would proceed is to put these witnesses on the stand so that we can ask, were case-related materials contained within the notebook that you
Well, what
read?
would, without knowing what the case-related materials are? I mean, how could I make a decision whether it was prejudicial to him if I didn't know what the case-related materials were? And if I did know that, and if there was, unless it was in chambers, or in camera, then where the Commonwealth couldn't hear, there would always be some suspicion that they might have some. If you think there's something relevant, how can you ask them? Is it case-related? It could be what day he was going to be down here. That's case-related. It doesn't mean that it would, impinge upon his rights, to have a fair trial. I don't know what you're trying to get to unless there's something particularly damaging in there or inculpatory that you think the Commonwealth knows or is going to use or take advantage of. I don't understand it. It's a tail chasing the dog here. I don't know. At some juncture, you're going to have to give me something that you think is prejudicial to your client that was in that notebook that the Commonwealth says they don't know about, but you want some proof that they didn't know about or who these people shared. Now, if you can bring up something, if you want an in-camera review of something that was prejudicial, that you feel like might be prejudicial to your client, if you want to have that, I'm sure the Commonwealth will allow me to view that in camera.
That's what I asked for in a motion.
If you can make that case, then we'll have a hearing. Otherwise, we're not gonna have. a hearing. Okay? Because nothing's been given to me that would indicate that your client has been prejudiced in any way about something that Corrections Institute people that have nothing to do with this county or even in this circuit might or might not have done. If they've been in violation of his civil rights, then you ought to take that up in federal court or a dare circuit, which I'm sure that you will at some juncture. But I don't even think I have jurisdiction over it unless you prove it has some relevance to this trial here. Okay? Thank y'all very much.
Judge, may we file a supplemental brief as to this
You
issue?
can file anything you want to. That's free country. Sure.
Thank you very much.
Butch Sally. Are you Butch Sally?
Yes, sir, I am.
Good morning.
Good morning, sir.
We're here on 25 CR 0047 for a pre-trial conference. Sir, were you born in 1972?
Yes, sir.
Last four digits, social security number 7397.
Yes, sir.
Okay, what does the Commonwealth have here?
Yeah, we seem to have a misdemeanor plea.
Okay, hold on.
Upon a plea of guilty.
Hold on. A motion has been tendered that says you wish to enter a plea today. Is that correct? I'm talking to you, sir.
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily entered?
Yes, sir.
Are you the same person that we just identified in 25 CR 0047?
Yes, sir.
Is your judgment impaired today?
No, sir.
Have you discussed these charges with your attorney?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? Have you reviewed the evidence the
Yes,
Commonwealth
sir.
has against you? You believe you're fully informed about your case?
Yes, sir.
You understand you do not have to enter guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand the rules. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea, that you give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept it. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and go to trial. You understand that? Mr. Commonwealth Attorney, Mr. Hunley, what's all?
Upon a plea of guilty to possession of drug paraphernalia, the defendant shall receive a sentence of 12 months, probated for 2 years. The probation is to be unsupervised so long as the defendant does not reside in the Commonwealth of Kentucky. in the event that he does become a resident of the Commonwealth, the probation shall be supervised. In addition, the defendant shall pay a fine of $200 and of course shall pay the fines and costs at the discretion of the court. Any paraphernalia and contraband involved in this case shall be destroyed according to the laws of the Commonwealth.
So what your agreement was?
Yes, sir.
Are you pleading guilty because you did commit the act charged in the indictment as amended down?
Yes,
Are you doing so of your own free will?
yes, sir.
Knowing your constitutional rights explained to us, you still your desire to enter this plea and allow the court to fix your punishment.
Yes, sir, yes.
Okay, is that your signature on the document?
Yes, sir.
What is the court cost?
The total of the fine will be $422.50.
$422.50. When can you pay that?
Sir, I've been incarcerated
No, just tell me when you can pay it.
90 days.
Okay, well, I'll tell you what, I'll let you pay, $100 within 30 days.
Yes, sir.
And the balance within 90 days, okay?
Absolutely.
Gives you some chance, okay? Now, probation and parole, even though this is not supervised, will you need some information from him?
I believe we got everything we need, Your Honor.
Okay, and when can he be released? There's nothing stipulation, he can't be released immediately, right? Okay. Now, I guess we do need an address though. Where you gonna be?
3152 Oak Knob Road, Lafayette, Tennessee, 37083.
Lafayette, is that different than Lafayette?
Well, I've been across the country. It's Lafayette, yes, sir.
Yeah, I mean, I thought maybe there, I know
No.
there's a La Follette down there too, you know, I didn't know. Make
Just
sure
out of
I had the right
Scottsville,
one.
Kentucky.
Okay, well, make sure we have your address and you'll be on your way. Okay,
Thank you, sir.
okay. Elizabeth Scott. Presidency.
Yes.
Commonwealth versus Elizabeth Scott, 21 CR 0056, 25 CR 003. So you are Elizabeth Scott.
Yes,
Good morning.
good morning.
You born in 1992.
Yes,
Last four digits, social security number 5440.
yes,
If you had an opportunity to look at this pre-sentence investigation report during probation parole,
yeah.
Yes,
is there any reason why, is it substantially correct?
It is
Counsel,
substantially
any reason why she shouldn't be sentenced?
no, Your Honor.
21 CR 0056, you received 3 years pre-trial diverted for 5 years. Pre-trial diversion was revoked on 8/28/25. On 25 CR 0032, you received 1 year to serve. And would that be a total of 4 years? Is that correct?
Yes, and I believe there was another case also. That's,
Six or 8 years.
yeah, I think it was something like that total.
How much?
He had 6 or 8 out on the other box. Got rid of the bus.
7 years, that's what, I believe that's right.
So I'm putting the 1 on top of the 3 is what here, and it runs consecutive or concurrent with what the other thing. I just don't have the information.
Yes. I believe there was a third case that she may have already been sentenced on.
Mhm.
So, and I think that one has the total amount.
Well, the Department of Corrections just a little sensitive about me sending things up there unless we tell them exactly what the sentence is, and I can't look pretty sensitive at this.
She had, on 22 CR 86, she pled guilty to theft, unlawful taking others. This is when she was working at the store and got into the lottery tickets, I believe. And she got 5 years on that sentence.
Yeah.
And she's already been revoked on that. So in this case, then while she was on probation, she got in trouble. She was placed into the drug court program
Myth.
with meth, and that sentence was run consecutive to the 5 years. And then when she was terminated from drug court, she had another possession charge pending. I think she got a year on that. Is that correct?
Yeah, that's correct.
So that's the reason they're all consecutive. I kept trying to help her out, hoping she would get straightened out, and she kept digging a bigger hole.
Yeah, I understand. So you're talking about 7 years, is that what you're telling me? What did the judge?
You got 5 on 25 CR 30, I'm sorry, 22 CR 86, you got 5 years. Wait, let me look. 21 CR 56 was 3 years. I think they were going concurrent.
That's 5,
Yeah, and then you've got
1 year,
25, 32.
1,
Yeah, one,
so it'd be 6 years.
6 years.
6 years. Well, Elizabeth, you know, everybody did everything they could to help you. From here on out, you're gonna have to help yourself. You know, you have a tendency not to be truthful and to fall off the wagon. But you're still a young person and you still have a productive life. How many children?
I got 2 kids,
Well, how old are they now?
2 and 8.
Well, you know, you're gonna still have an opportunity to get out in time to be a good parent. And luckily for you, you got a good support system around you. You got a lot of relatives that love you and love them and everything. But you brought this on yourself. There's nothing I could do or your attorney or Mr. Stockton can do about it. So I hope when you're there, you work on this addiction problem. And you also have a little problem with truthfulness on occasion. You know, will you acknowledge that? Okay, so work on it. I hope things turn around for you. Okay, thank you. Okay, Daniel Appleby. Daniel Appleby.
Not here, Your Honor. He has paid a payment on his child support since he was released from custody. So I want to hold my motion to revoke an abeyance. And if he stops paying, I'll come back and renotice
Okay,
that.
so we'll just take it off the docket and you'll reschedule if
That's
necessary. Julia Bush. Are you Julia Bush?
Yes, sir.
Good morning. You're here on 25 CR 0053. Were you born in 1981?
Yes.
Last 4 digits are Social Security 9070.
Yes,
You're here for sentencing.
yes, sir.
Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Is it substantially correct? Counselor, is any reason this lady should not be sentenced?
No, Your Honor.
On plea guilty to trafficking and controlled substance, first degree meth, the defendant shall receive 3 years, serve 90 days in-home incarceration, probated for 5 years, probation to be supervised. Be allowed work release, attend church and doctor's appointments following home incarceration. What are the court costs here?
$185.
Court costs $185. I'll let you pay that first payment 30 days from today, $40 a month, so you get that paid off, okay? All right, well, can you do that?
Yes.
You meet with probation parole officer. Thank you. Caroline Hardison. Caroline Hardison. This is 24 CR 0080. Are you Caroline Hardison? Good morning. Were you born in 1988? Last 4 digits, social security number 3232. What's the Commonwealth have to say?
Your Honor, we met on this at the negotiation day and we're having some difficulty. We've talked about this case this morning. We need at least one more negotiation day on this.
Negotiation date on November 14th and your next court appearance is November 20th. Okay?
Thank you, Your Honor.
Yeah. Commonwealth versus Joseph Parham. Commonwealth versus Joseph Parham, 21 CR 0012. Are you Joseph Parham? Good morning. Were you born in 1993? 1996. Last 4 digits is social security number 6766. You're here on a probation revocation. What's the Commonwealth have to say?
Your Honor, Mr. Parham's been on probation since December of 21. He's had 7 positive tests for meth. After the first 4 positive tests, he went to Healing Place and completed treatment and is even working for the Healing Place. But evidently he got back on meth and was discharged from there. And he's had 3 positive tests for meth since, the latest being October 3rd, 2025. So my recommendation is to revoke his probation. The only other alternative I see for him, if the court wants to do it, he was in drug court many years ago. How long was that, Mr. Cron?
Graduated 2018.
Yeah, so I don't know if you want to put him back in drug court or revoke his probation. That's what about.
Your Honor, he's enrolled in an IOP program. I think today may be the first day we're supposed to meet with him. Is that correct?
Tomorrow.
Tomorrow, so he just would ask that you allow him to attend an IOP program, work on his dick.
Look, you know, he's been to drug court. I mean, if the General Assembly changes the law and says it's all right to use methamphetamine, then he can go on his way rejoicing. But that's not what the law is. So I at some juncture, it'd be better just to get it behind you. Have you been able to work? Have you been working all this time? Right?
I have an interview with Sumitomo in Edmonton on Monday.
Have you been working though in the last 4 or 5 years?
Just moved back down here.
Have you been working? I didn't ask you where you lived or what you had for Christmas. I just asked you, have you been working
I worked at the Healing Place for the past 3 years.
other than working there? Yeah. What does the Commonwealth have to say?
He's a 3-year possession case. He won't have to be in there long probably.
The
before he
best
makes
thing you do,
parole.
just get this behind you. You're not going, you can't comply with the rules here, so I'm gonna revoke. And I think that's the least restrictive thing I can do, and you'd be on parole and it's not as heavily supervised as probationary. Okay, thank you very much. Deborah Polson. Commonwealth versus Deborah Polson, 25 CR 0050. Are you Deborah Polson? Yeah, you were born in 1976. Last 4 digits, social security in 9887. You're here for sentencing. You had an opportunity to look at the pre-sentence investigation report done by probation and parole. Have you gone over this with her?
Yes, I have.
Have you seen it, ma'am? Okay, is there anything in there that's not correct? Okay, upon a plea of guilty to possession of controlled substance, first degree methamphetamine, you shall receive a sentence of 2 years, probated for 4 years, supervised. Complete the Cumberland County Specialty Court. Are you disabled? Do you work somewhere?
No, I'm kind of on this end.
She's filing for disability right now. She's in the process.
Okay, well, I will, she been interviewed, accepted in the drug court yet? Anybody know?
Yes,
When she started orientation?
You started last month. Was that your first last month?
She's in drug court already.
Yes.
Okay. Okay, well, I will, what are the court costs in this case? What much? $215. I'll let you pay $30 a month, first payment, 30 days from today. You need to get information, probation, parole officer.
You good, John?
You good? Okay.
Thank you.
Ashley Stotts.
Good morning, Your Honor.
Commonwealth versus Ashley Stotts, 21 CR 00150. Pretrial diversion rep. Were you born in 1984?
Yes, I was,
Last 4 digits, social security number 8511.
yes.
What do you have to say to Commonwealth?
Your Honor, this is a review. You passed it till later this month.
This is the marijuana card.
That's correct. And since last month, this started out as a fraudulently receiving benefits case, and she's paid all the restitution on that. But then she tested positive for marijuana. She had a marijuana certificate. But now she has a legitimate marijuana card issued. Who's it issued through? Jeremy, the Department of, got a copy of it. Whatever state agencies issuing those now.
Yeah, I met with the person yesterday at Judicial College.
Yeah.
And they also told me,
Office of Medical Cannabis. I didn't get it wrong.
yeah, and they also told me, when she was here last time, she testified that she legally bought it in Ohio. Is that right?
2 years ago. Yeah.
No, I'm talking this marijuana that you had.
That's what she said.
Yes.
Yeah, well, The problem is you can't legally go to Ohio and buy marijuana and bring it to Kentucky. That's illegal. The only way you can use one of those medical cards in Kentucky is to go to a dispensary here in Kentucky, and there's only one of them open, and that's not where she got it. So she violated Kentucky law. She's in violation. So I'm gonna revoke the pretrial diversion, and we'll schedule it, have a sentencing hearing. It's not that I'm not gonna probate her, but I'm not gonna go down this road here where everybody gets a medical card and illegally gets marijuana and comes in here and starts doing these tests. We're not gonna go down that road.
Your
So-
Honor, if I may, did you testify last time?
I didn't testify.
I don't believe we.
Well, she told me that's where she got it.
Yeah, we didn't have.
Listen, there's no place where she can get it legally with that marijuana card.
Well, Your Honor.
You wanna raise your right hand? You wanna swear the testimony you're about to get is the truth, the whole truth, and nothing but the truth? Okay, lower your hand. You can inquire. I wanna find out, where did you get the marijuana that you used? Okay, now she's testifying.
I could get it and they advised me of it.
Yeah, well, it's
It's
the only
wrong.
way, and it's illegal to go to Ohio to buy marijuana, even if it's legal, and bring it back into Kentucky. You can buy it and use it in Ohio under a reciprocal agreement with Kentucky. With that, if you have a card, but she didn't have a card. So that's the way it is. That's what my ruling is, and you can appeal it if later on, okay? We'll schedule a pre-sentence investigation report. We'll schedule sentencing on November the 20th. Okay, Rebecca Thompson. Pardon? No, I'm gonna leave her out on bond. I'm not gonna take her into custody. Okay. Rebecca Thompson, are you Rebecca Thompson? Okay, were you born in 1980?
Yes,
Last four digits, social security number 7406.
no,
Pardon?
9406.
9406. Okay, we're here on 25 CR 0074 for arraignment. It's a rocket docket thing. So you're here by information. By information, you entered, the information was entered in your case, charging you with possession of controlled substance, first degree meth, from 25 F 0053. Since then, it's become 25 CR 0074. You acknowledge the receipt of the information,
Yes,
again,
sir.
your client, waive formal reading and arraignment. She's entering a guilty plea. Is that correct?
That's correct.
Okay. A motion has been tendered that says you wish to enter a guilty plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in the information?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed the charges with your attorney?
Yes.
Are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you?
Yes.
You believe you've been fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea?
Yes.
You have certain rights under Kentucky, United States Constitution. Before I accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter to a higher court if you lose. The right to require the Commonwealth to prove on a reasonable doubt that you are guilty of the charges against you. Understand that by entering a guilty plea, that you give up those rights. You understand
Yes, sir.
that? I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided law. I don't have to accept the recommendation prior to accepting any recommendation in this case. I will lay a pre-sentence investigation for. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea. Understand that? In
Yes.
case I do not accept the Commonwealth's recommendation that you're about to hear and decide to impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. In other words, I can't sentence you to any more than you've agreed to.
Okay.
Okay. Mr. Hunman,
Yes, Your Honor, upon a plea of guilty to possession of a controlled substance, first degree, The defendant shall receive a sentence of 2 years on each charge, apparently there's two, to run concurrently for a total of 2 years, probated for 4 years with the probation supervisor. The defendant shall be assessed by a social service clinician and shall follow any recommendations of the clinician. The defendant shall, of course, receive credit for time served. She shall also, as a part of probation, obtain gainful employment or do a minimum of 30 hours community service until gainful employment is obtained. Defendant agrees to have any evidence in these two cases disposed of in a manner consistent with the laws of the Commonwealth.
Is that your understanding? Okay, are you pleading guilty because of your own free will and because you are guilty of the charges amended?
Yes, sir.
On constitutional rights is to your desire to proceed, allow the court to fix your punishment within the range permitted by law. You understand that after entering this guilty plea, any future convictions of felonies could be enhanced under the persistent felony offender law. You understand that?
Yes, sir.
Is that your signature on the motion and all?
Yes.
I'll accept the order of precinct's investigation report and schedule sentencing on November the 20th. The probation parole officer right there. Elizabeth Watson. Commonwealth versus Elizabeth Watson. 24 CR 0086. You are Elizabeth Watson.
Yes,
You were
sir.
born in 1970. Last four digits, social security number 8925.
Yes.
And you're here on a probation revocation. What do you have to say, Mr. Stockton?
Your Honor, this revocation, she has a 3-year sentence on possession of a controlled substance first offense. And the violation was that she is positive for meth and attempted to alter the results of the drug screen. I can call Mr. Garner if you want me to.
Yeah. Well, I'll take judicial notice of the fact that I heard news reports that there's been a wreck that you were involved in since it was that correct?
Yeah, and I checked into that. I called Sheriff Keaton Williams and Mr. Williams, Sheriff Williams couldn't tell me that she had any other signs of impairment other than the fact that she didn't brake and ran into a bluff, that she traveled a lot. So he had her tested and she consented to a blood test. And that's the reason I didn't make that part of this motion, because he didn't have
Do
any
they have the
other.
results of the blood test?
No, it'll probably be a month or two.
Okay. Bring witness around.
Okay, we will stipulate, A, there was an altered test, and B, there was a subsequent, bad test. There have also been good tests since, but we'll go ahead and say
Well, if
it.
you stipulate, there's no reason to bring him on.
Yeah.
It's Commonwealth have said.
Well, this is my standard motion, Your Honor, when somebody attempts to alter a test, so I'm asking for revocation. Ms. Watson, this is her second go around in the last few years. She had a previous possession. We put her in drug court. She didn't last very long. And then she got the new possession. And, we was in court last time. I've got the test results here. She was 10,000 nanograms per milliliter, how high her test results was. And I told the court at that time, I was extremely worried about her safety and other people's safety. And then subsequently, she has this wreck. I'm not saying she was, thankfully, everybody was gonna be okay.
I remember saying myself is I hope nothing happens to you
Yes.
between now
So,
and then, and I'm not saying anything has,
right.
but
And Your Honor, we're looking forward to those test results coming back. I'll say that.
you looking forward to what?
To the test results. We look forward to, Ms. Watson indicates they will be good.
Yeah.
And
I just think there needs to be something rather than IOP if she's in some type of treatment. I don't want her to go down this road, hopefully. And when you alter a drug screen,
The
you've got a
altering
problem.
thing is just
You got a
almost,
problem.
it's more than I can stand.
Yeah.
It's just more than I can stand. It's bad enough that you're addicted, but that take advantage of an opportunity that's been given to you, you alter it. So I'm going to revoke.
Your Honor, may I address the court before you?
Well, I've given you an opportunity to, but I'll give you the second bite out of that. Yeah, go ahead.
Your Honor, the 17-year-old daughter remains in Vanderbilt
Yes, sir.
Hospital. Ms. Watson is, of course, her caregiver. She's the one that sees about her. Her mother is 77 years old and unable to see about it. And under this set of circumstances, with the daughter being in the situation that she's in, I would request that any ruling or any disposition be continued until we have an opportunity for the daughter to get out and be situated.
I want her tested today. Go out and be tested before I make a final decision on this. You have a matron or someone, you know.
Thank you.
We got,
Officer Foley back there.
oh, Officer Foley.
Go to my office.
Yes.
It's out there. Officer Foley will get you to.
We'll come back to that. Okay, that finish it out of custody. Now, is Eastern Kentucky Correctional Complex on the line? EKCC,
Yes, sir. One moment, please.
thank you. Hardin County, if you're on the line, you're next. Hardin County, if you would turn your camera off until I call your face, you're next. Commonwealth Kentucky versus Paul Bricker, 22 CR 0084. Are you Paul Bricker?
Yes, sir.
We're here for a pretrial conference. Your attorney, Mr. Costello, is here. What's the Commonwealth have to say?
No, we've been negotiating in good faith, and I think we're close to resolving this case, but because of the logistics, we need one more month.
We're within,
You need to speak up.
sorry, Your Honor, we're within a couple of years. We're the closest we've ever been on this case.
Okay, you want a negotiation on November 14th and the next court date, November 20th?
Your Honor, because of my medical leave that I have to have, I spoke to Mr. Stockton about the December date. If that would be agreeable to.
I don't want,
Well, he's in state custody. He's gonna be there for several years. She has a legit.
okay,
medical.
I was gonna say, suggest you. So what is your let's just schedule it then for December 18th. Mr. Bricker, your attorney has a medical leave coming up. They say it will not affect the amount of time that they're serving and have the hearing in December instead of next month, okay? So they'll be able to talk to you about that. So there'll be continued negotiations and your next court date is December the 18th. Eastern Kentucky Correctional Complex, thank you for cooperating. Y'all are excused, okay?
Thank you, sir.
Hardin County Detention. Roder, you're next. Roder Corrections next after this. Hardin County Detention Center, we have 24 CR 0072 Wesley Smith. Motion for shock probation. What is the what do you have to say?
Well, we continue this a month to see what kind of plan he might have as
Yeah,
far as work and where he's gonna stay.
yeah, I did find out as far as where he's gonna stay. He's gonna stay with his mother, and I have her address as well.
Well, I want him to tell me what he's got planned up. Wesley, you raise your right hand. Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir.
You can inquire from the Commonwealth.
Yeah, Mr. Smith, where do you plan on living if you're released?
With my mother, Tammy Pruitt,
Or what county is that in?
Cumberland County.
Okay, and what plans do you have for employment?
I have a job with Brown Construction doing concrete work.
And, is this gonna put you out of the drug business for good?
Yes, sir.
What was he charged with?
He was charged with trafficking. He had a little over 3 grams. I dismissed the other case in the case, and he served about 11 months. So I think if he's not learned his lesson by now, I don't know that he will.
How much time does he have left?
He's got, according to this, he's parole eligible in July of 26. And if he had to do a serve out, it's another 4 years. But of course, with good time and everything, it wouldn't be that long. But he served right at 11 months, counting the time from last month.
Well, I'm gonna take a chance on you, but I'm gonna take some restrictions on this thing. On the shock probation. What kind of strict supervision, Mr. Garner, can we put him under?
He can report to me and we'll go over the conditions. You already got him on curfew.
Yeah, I want him on a curfew for at least a while.
Right here.
I want you to stay at your mother's house except you go to work, church, or the doctor. And the
Yes, sir.
probation and parole officer, and we have frequent drug tests on him.
Can we just set this for like 3 months out and he'll stay on curfew till then, and if he's doing well, we can take it off?
We'll schedule you to your next hearing. I'll sign an order allowing you to be released immediately. Your next hearing review will be December 18th to make sure everything's going all right. That's 60 days out. Okay, and by then I want you to give, you need, as soon as you get out, you need to go to the probation and parole office and sit up with Officer Garner, okay?
Okay,
Okay, thank you very much.
thank you, sir.
Roeder Correction Complex. Hardin County, thank you for cooperation. Roeder,
Yes,
would you turn your camera on, please?
it should be on. Hold on.
I didn't hear the first part.
Megan said that you do a release order because he was stating like she can't release it.
Y'all need to submit an order on that last case as far as Mr. Smith
Yeah,
to let us sign it. And if you get it, we'll sign it today, get it up there. Okay, this is at Roeder, this is Commonwealth versus Robert Tabor, 25 CR 00050. Are you Robert Tabor?
Yes, I am.
Born in 1987.
Yes, I am.
Last four digits, social security number 3596.
Yes.
Okay. What do you, what's the Commonwealth have?
All right. DCBS now requires a court order for us to obtain their records. That court order has been submitted. Ms. Vanderpool's checking on the status. We've not received those yet. We definitely need another negotiation done.
Negotiation day on November the 14th.
Yeah.
Next court date on November the 20th. Your attorney will be in contact with you. And the purpose of this was, so he'll know what the purpose was, is we had issues.
Yeah, so they can have full discovery and then
Well, you need to make a full sentence so he can understand.
Well, we will have to obtain the DCBS records to furnish to his counsel so they can be reviewed, and then we can proceed.
DCBS stands for what?
Department of Children, I don't know what the B for anymore, Bureau of Services, so
Okay,
they change all the time.
I know they do.
Yeah,
It's acronym heaven. So your attorney will be in contact with you, Mr. Tabor. And Broder, you're excused. Thank you for your cooperation.
Thank you.
Adair County Regional Jail is on at 10:30. We're going to take a short break before then. Okay, everybody have a seat. Let's come to order on the record. Okay, we're gonna go to Adair County. You turn your camera on. Do we have any results from this?
I'm getting your
Okay.
Your Honor, the test revealed that she was positive for Suboxone, and the tattletale tamper on the right-hand side indicated that she may have consumed something that would alter the results of that test. So we have sent it to the lab for verification.
And
And I'd say there really no way to know if it's accurate to its lab, because we had one drug court this morning. The lady had a false positive on fentanyl, so I would say we need a lab.
Your Honor.
Wait
she
just
was
a
tested
second. Wait
Monday
just a
and-
second. Wait just a second. I couldn't hear what you said,
I
Mr.
just
Stockton.
don't, I would think that the lab needs to be, get a lab result before anything's done, because I don't wanna treat Ms. Watson improperly
What,
because.
I didn't hear what you said.
Well, I said we had a lady
Wait,
that's-
wait till I ask the question.
Okay.
I can't hear for some reason.
Okay.
Here, okay. What did you say happened in drug court?
We've had instances here lately in drug court, people having false positives on fentanyl and things from urine tests, so I just think we probably need a lab to be certain if it's accurate or not.
How long does it take to get a lab?
About 2 weeks, Your Honor.
Well, I'm gonna hold in abeyance any revocation on this thing to give you a couple of weeks to try to do something with your daughter. But I want you back here on I guess we might as well wait till November 20th. But I'm telling you, Miss, you know, you need to live at the foot of the cross. I've had about all I want.
I appreciate
Well, I hope you do. And if you come back dirty,
Yes, sir.
if you come back dirty on this car wreck, you know, there probably gonna be some other repercussions on the thing. So I don't know if you've got anything that you need to tell your lawyer, to tell the Commonwealth, that it'd be better to get up front to try to get this behind you than it would be to come up here and make a representation that you were clean, and then he comes back dirty, and now we got this Suboxone on here and stuff like that. You know, the thing about it, you can lock a thief out, but you can't lock a liar out. And if I find out you're lying to me, it will not be good. You understand what I'm saying? Okay. See you back here on the 20th, and if we get that result back in, it might be before then. We might issue a summons.
Mr. Cross and forward what the result of that.
Okay, thank you very much. Okay, let's go to the Adair County Regional Court. Correction Institute. Timothy Boggs.
Yeah.
Commonwealth versus Timothy Boggs, 25 CR 0021. You are Timothy Boggs,
I am.
born in 1999.
Yeah.
Last four numbers, your social security 4290.
Yep.
Sent by Mr. Poindexter of a pretrial conference. What do we have, Mr. Stockton?
We have in this case.
You need to get behind the microphone so I can, please.
He's a co-defendant with Thomas Huff. In this case, we had a plea worked out and he wasn't present for sentencing. And
Had a plea worked out.
we
What?
had a plea agreement worked out and he entered the plea and he didn't appear for sentencing. And I've
Mr.
been,
Boggs did?
no, he did not.
Correct.
And he has furnished documentation saying that he was he had an appointment with his probation officer in Madison County, Indiana. If I can show it to the court,
That's all right, you know.
just go ahead and take it.
What was the agreement? What was the agreement?
I'll have to
What
look.
was the plea agreement? You'd already pled and then we were supposed to sentence him, right?
That's correct. And the agreement was. He was going to plead and take a sentence of 6 years, serve 60 days home incarceration with the balance probated for 5 year supervision was the agreement.
And We were supposed to sentence him, he didn't show up.
He didn't show up on August 28th of this year, and I don't know how he got back in custody. It's October now. Evidently, he wasn't around on the September date either.
And if I can address that, Your Honor, I spoke to Melissa Leonard, who is his probation officer in Indiana. She advised that their procedure there is if you want a travel permit to travel out of state, you file an application, they have to get it approved by the circuit judge. He has to sign off on it before you leave the state. Instead, him and his father had called the probation officer the day before to say, we have court in Kentucky. We need to go down there tomorrow. She said that she didn't believe them. So she wouldn't give them a travel permit and instead told them to report the next day.
Didn't reflect well on him that his own probation officer was going.
Well,
I understand.
I don't know if she didn't know he had charges or why it was, but she said that she did send, there is a copy in his father's file where she sent a letter
How did he
down.
get back here? How's he in custody?
They turned themselves in, Your Honor,
Who did?
him and his father both on Tuesday.
Is his father charged with criminal activity too?
Yes, sir. They're co-defendants in the same incident.
I didn't see him.
And I didn't realize his father's son, Thomas Huff, is his father.
Yes.
Okay. So they're both charged on the
So
same
he's
case.
standing here for sentencing today?
Well, he was on for sentencing August 28th, whatever the court wants to do. If you want to,
What's your position?
well, if I've made my agreement, but if, I've not made an agreement with Mr. Huff. So if your court wants to clear the decks, we can start over at the pretrial conference. Because I've never met with Mr. Huff's attorney and had a pretrial conference, I don't think.
No, we had, originally had an agreement for a misdemeanor, but he didn't appear for the same reason.
Okay, well, that's the reason there was entered, because he didn't appear for the negotiation.
No, he appeared at negotiation, wasn't here to enter the plea because
Okay.
his probation officer wouldn't allow him to
Well,
leave.
what does, what we're gonna do with Mr. Huff have to do with what we're gonna do?
Oh, I
with
was just letting
Mr.
Mr.
Boggs?
Stop.
Well, they're co-defendants, so I just want them both to enter the pleas if there's going to get it off the books. Same time, we've not had much coordination, I guess, so I should say.
Okay.
Where is Mr. Huff on the docket?
Yes, he is.
He's in jail over there?
Yes, sir.
I don't see him on the docket. Oh, he spells it Hough.
Yes, sir.
Well, it says a pretrial diversion revocation. Here's what it says.
See if I can see what's going on in his case. We did have a misdemeanor plea prepared for Mr. Huff. So if the court wants to enter the felony plea and he wants to enter the misdemeanor plea today, we can get those.
It's a sentencing for Boggs, though.
That's correct. We had to sentence him and do the
Plea
misdemeanor.
for Huff.
We had to go
Is
to
that
PSI.
correct?
That's my understanding, Your Honor, yes.
I've done for pretrial conference, because I wasn't sure if PSI was going over with.
Okay.
I don't know if the court would consider it, Your Honor. Since we've got things straightened out with the probation officer, if they could be released back out on their bond.
They're not gonna be released.
Well, I was gonna say, and then reappear here.
No, they're not gonna be released. You know, we've got them down here and I'm not going to let them go back up there and depend on some judge signing an order that they can come back down here. We got whatever we're gonna do with them, we're gonna do with them while they're here.
Okay, Your Honor.
Great. Thank you. Thank you for agreeing, but I'll wait.
Well, if you want to go ahead and sentence Mr. Boggs. if
Well,
he's
here's the
ready.
thing about it is if Mr. Huff is gonna enter a misdemeanor plea, we don't have to have a pre-sentence investigation. We could have him enter a plea today and sentence him today on a misdemeanor.
That's correct.
Yes, sir.
And that would clear that off. And then we go ahead and sentence Mr. Boggs after Mr. Huff does his plea. And then I'll take a look at whether I'm gonna accept the plea on probate 60 days or make him serve a portion of it because he wasn't here.
Okay.
So, and you can talk to him about that. So we'll come back to them if somebody needs to do the plea agreement papers on Mr. Huff.
Thank you.
Okay.
I didn't.
Well, now we'll have Jimmy Clark on the rocket docket.
Okay. Just switch him. Yeah.
Jimmy Clark.
Yes, sir.
Arraignment on the Rocket. Do y'all have anything for me on Jimmy Clark? Commonwealth versus Jimmy Clark, 25 CR 0063. Are you Jimmy Clark?
Yes, sir.
Good morning. What's your year of birth, Mr. Clark?
9/28/87.
1987 is your year of birth. What the last four digits of your social security number?
3975.
Okay, you're here today for arraignment on information. The information says that on the 11th day of September, you committed the offense of possession of controlled substance first degree, methamphetamine. And also that possession of controlled substance first degree hydrocodone. Counselor, you acknowledge the identity of your client, receipt of the information, waive formal reading, and you're about to enter a plea of guilty on this?
Yes, Your
Mr. Hunley,
Yes, Your Honor.
as soon as I go over the rights here with this individual, we'll get to you. A motion's been tendered, sir, that says you wish to enter a guilty plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Okay. Is your judgment impaired today in any way?
Yes, sir.
Is your judgment impaired in any way? You know what's going on here? I mean, you're not under any undue influence or anything? You're not
No, sir.
impaired? Okay.
No, sir.
Have you discussed these charges with your attorney, and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Feel like you're fully informed about your case?
Yes, sir.
Understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you fully understand those rights. You
Yes,
have the
sir.
right to testify against yourself. No one can make you say anything. Your right to speak, trial by jury, your right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, your right to produce evidence, your right to call witnesses in your favor, your right to appeal this matter to higher court if you lose, your right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that about entering a plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence by law. Prior to accepting this recommendation, I will await a pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. Listen very carefully to what Mr. Hunley says the Commonwealth's recommendation is. Mr. Hunley.
Your Honor, upon a plea of guilty of possession of a controlled substance, first degree, 2 counts, the defendant shall receive a sentence of 2 years on each charge to run concurrently for a total of 2 years, probated for 4 years with the probation supervised. Terms of probation include that the defendant shall be assessed by the social service clinician and shall follow any recommendations made by them. The defendant shall receive credit for time served, shall obtain gainful employment or do a minimum of 30 hours community service per week, and agrees that any evidence in this case be destroyed according to law.
Is that what you agreed to, sir?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended? Or in the information rather as amended?
Yes, sir.
You're doing so of your own free will?
Yes, sir.
Your constitutional rights I previously explained to you, is it still your desire to give up those rights and enter a plea of guilty to the charges and allow the court to fix your punishment? Is that right?
Yes, sir.
Understand that after entering this plea, any future convictions could be enhanced under persistent felony federal law. Is that, you have the document here where you hold it up?
I don't have the document, I believe the original.
Did you see where the original is? Is that your signature there, sir?
Yes, sir.
Okay. Okay, I'll accept the plea. I did tell you that, any future convictions could be enhanced. I did tell you that, I believe. Is that correct? I did
Yes, sir.
tell you that if you have felonies in the future, after entering this plea, you could be charged under persistent felony offender law. So it would be more serious than any future felonies. You understand that?
Yes, sir.
Okay. I'll accept the agreement, order pre-sentence investigation report be done, and we'll schedule sentencing for November the 20th. Okay?
Thank you.
Your attorney will be up to see you. Barry Gibson. Barry Gibson.
Yes, sir.
Good morning. Are you Barry Gibson?
Yes, sir.
You born in 1969?
Yes, sir.
Last four digits of social security, 9632.
Yes, sir.
What does the Commonwealth have to say?
No, this is a motion to revoke pretrial diversion. And there is some substantial charges that we want to present to Clinton County Grand Jury. And I was going to have Trooper Poole here to testify to that today, but he's in service, and Mr. Rutherford asked that we continue it for a month, and that's all right with me.
It will continue this case until November the 20th for testimony. When does the grand jury meet over in Clinton?
November 3rd, I believe, or 6th.
The
So
sixth, I
you'll,
believe.
so this gentleman will be informed by the 20th on what the grand jury has done on the 3rd. So that way, if you got some stuff need to be wrapped up, Mr. Gibson, it can be your attorney be talking to you, okay?
Okay.
Thank you. Brandon Polston. Brandon Polston. Are you Brandon Polston?
Yes, sir.
Good morning.
Good morning.
Born in 1984.
Yes, sir.
Last four digits of social security number 6513, sir.
Yes.
We're here on a 404, it's just a 404 news notice. What does the Commonwealth have to say?
Quite a bit, Your Honor, above and beyond this motion. I learned this morning from Mr. Stockton that he'd had a conversation with one of the people that were there the night of this encounter that resulted in these indictments. He's learned information, without a doubt, is seriously exculpatory in this case. That information somehow didn't make it into any police report.
Where is this attorney? Where is Mr. Lewis Strack?
I'm sure that he doesn't know about this. He is an attorney in Lebanon, Your Honor.
Yeah, I know who he is now. Yeah.
I can send him a message right now, Your Honor, to see, I believe he has court in Marion Circuit right now, but I can send him a message to try and get him on Zoom.
Now, this case had some weaknesses, Your Honor, before we learned this. In discussion with Mr. Stockton this morning, he has suggested, and I concur, and I was ready for trial. But I think we ought to just dismiss this on Mr.
Well, Brandon, we can't dismiss your case unless your lawyer's here. You wouldn't want to dismiss, would you?
But,
I mean, you want us to go ahead and dismiss it before your lawyer gets here?
Fine with me, sir.
I think that's the right
that
answer.
is the right
That's
answer.
a good
Yes,
answer.
sir.
He has a 10-year state prison.
Okay, well, on these charges here, on the motion of the Commonwealth, your trial is not gonna happen. These charges are dismissed with prejudice.
Yes.
So it can't be brought back up, so
Yes, sir.
nothing else good happens to you today, man. You got one good lick, okay?
Thank you, Judge.
Okay, see you later.
See you.
Thank Mr. Stockton with an inquisitive mind.
Silas Tabor. Silas Tabor. Are you Silas Tabor?
Yes,
Good morning. Were you born in
Morning.
1976?
yes,
Last four digits social security number 6042.
yes.
Okay, we're here on a pretrial conference on 25 CR 0054. What does the Commonwealth have to say?
He's a co-defendant, well, not a co-defendant, but he is charged with sexual assault on the same victim that Robert Tabor is charged with. We're also waiting records from the Department of Community-Based Services. So we can furnish those to Defense Counsel and then have a pretrial on this. I hope to have one so we can do it November the 14th and November the 20th.
And I will have somebody, because I will not be here, I'll have somebody standing in for Mr. Tabor. I believe when Mr. Stockton and I, were discussing this case previously, that it's our suspicion and assumption that once we review these records, it will most likely be dismissed in Cumberland County because there's a companion case in Monroe County and where venue is appropriate.
That's correct.
Yes.
Okay, they got some records from community-based services, Mr. Tabor, that they've got to get. And so we're gonna reschedule this for a negotiation day on November 14th in your next court appearance on the 20th. But if you could hear, they think that maybe this case here might be included, dismissed, and the case in Monroe County continued, which means you only have to fight it at one place. So I'll go ahead and enter the order of that effect. Your attorney will be able to explain it in more detail, so you can have some privacy there, okay?
Well,
Okay, thank you very much. Brian Thompson. Brian Thompson.
Yes, sir.
Are you Brian Thompson?
Yes, sir.
Good morning. Were you born in 1980?
Yes, sir.
Last 4 digits, social security number 4324.
Yes, sir.
We're on 20 CR 00060 on probation revocation. Is public advocate representing now?
He seemed unsure whether it was gonna be Mr. Garrett or me yesterday. I spoke with him for a few minutes.
Well, Mr. Garrett probably represented an underlying thing that has not been
Which
retained.
was back in 21,
You what?
which was back in 21, I believe.
20, it looks like.
20, yeah.
Have you talked to a lawyer yet, Mr. Thompson?
Yes, Mr. Ted.
He spoke with me for a little bit yesterday.
Okay. What, are you ready to proceed with this thing, or
I would like to get one more day if possible.
what? Just tell me what the basis of this is.
He was pled to possession of controlled substance, got a 3-year sentence. He was Officer Garner was trying to get his probation transferred under interstate compact to Tennessee. And he'd have to explain it better than me, but he tried once and they couldn't find Mr. Thompson. So he tried again, and evidently in the interim, he got on probation in Tennessee and absconded from probation in Tennessee. And basically absconded from Kentucky too, because he never could get signed up on probation. So he's been on the lam for about 4 years. Now, I know a good portion of that he was in jail. So,
Okay, we'll have a negotiation day on November 14th and the next court date on 20th. And counsel, I think it'd be good for everybody concerned if you will find out what this gentleman's situation is down in Tennessee. And so our Commonwealth attorney might coordinate something with them.
I think he served out his time in Tennessee.
Yeah.
That's correct.
Finished in Tennessee?
Yes.
Okay. Okay, we'll take, your attorney will be overseeing, you have a negotiation day here on the 14th, the next court date will be the 20th. Hopefully we wrap this stuff up for you, okay?
All right, thank you.
Thank you. Okay, so we're down to Timothy Boggs and Thomas Huff. You got the paperwork done on Mr. Huff yet?
Mr. Poindexter said he was going back to send them, and that's why it's not current anymore.
He said what?
Mr. Poindexter said he was going back to fax that to the jail and have him signed.
Mr. Huff, there's gonna be some misdemeanor plea papers faxed up to you. Have you gotten those yet?
not yet, sir.
Okay, if you just will, we're in no hurry here. We'll just let you get an opportunity to get those so you can talk to your lawyer about it, and then we'll call you back up, okay?
Okay.
And then we'll go in recess till those get up there, and then after you do Mr. Huff.
Paperwork for Thomas Huff from the clerk's office yet.
Do what? Hello?
They're printing it off now.
Okay, well, we'll need some, are you gonna go somewhere and go over the stuff with him, Mr. Poindexter?
Yes, sir. Over the phone.
Okay, okay.
Spoke to Megan.
Well, she just said she got him up there, so he's got the papers. You're gonna call up there. And we'll hold Mr. Boggs and do Mr. Boggs right after Mr. Huff. Is that correct? Where did Mr. Stockton go?
They're gonna come get him, take him over to booking so he can call.
And then so let's go off the record just for a minute until we get those two papers, work on those two people ready, okay? I need to turn this off here somewhere.
Do you wanna go ahead and do show calls?
Okay, Commonwealth versus Thomas Huff, 25 CR 0022. Mr. Huff, you previously been identified as for your date of birth and your social security number. I understand that we have a misdemeanor plea. Is that correct, Mr. Hunley?
That's correct, Judge.
Okay, I'm gonna go over some things for you, Mr. Huff. Motion been tendered says you wish to enter the vote today. Is that correct?
Sir?
Are you currently under the influence of drugs or alcohol?
No, sir.
Be freely and voluntarily given.
Yes.
Are you the same person that we identified previously in 25 CR 0022?
I am.
Your judgment impaired today? Is your judgment impaired today? You know what's going on.
No, it's not impaired, Your Honor, at all.
You said you've had an opportunity to discuss this matter with your attorney, and are you satisfied with his advice?
Yes.
Have you viewed the evidence Commonwealth has against you? Feel like you're fully informed about your case?
Yes.
You understand that you do not have to enter guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right, and I'm gonna go over, but you have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented, counsel to jury trial, right to confront, cross-examine all witnesses, call, testify against you, right to produce evidence, right to call witnesses. In fact, we have process issue, appellate attendance. You have a right to appeal this matter to higher court if you lose, and right to part of the Commonwealth prove on a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes, I do.
Still the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. This is a misdemeanor case. So if I accept the plea, the judgment will be entered today. In the event, however, that I don't accept the plea, we'll try to give you more than you have agreed to. You can withdraw your plea and go to trial. You understand that?
Yes,
Hey,
sir.
Mr. Huntley, tell us what the Commonwealth's recommendation is.
Yes, yes, Your Honor, I'm going to plead guilty of possession of drug paraphernalia.
Wait just a second. You need to move over this center place. It's not picking it up there. That's okay. Well, that's good. Go ahead.
I'm going to plead guilty of possession of drug paraphernalia. The defendant shall receive a sentence of 12 months, probated for 2 years. The defendant shall pay fine and costs at the discretion of the court, shall obtain gainful employment of 30 hours a week or do community service. Agrees to have all drug paraphernalia, etc., destroyed in compliance with the Commonwealth. The defendant is to remain on active supervision until all fines and costs are paid in full. Once that is done and he removes himself from the residence of the state of Kentucky, he'll be unsupervised.
You didn't recommend a fine.
Did not.
Okay. Is that what you understand, sir? Shuff?
Yes, sir.
Are you entering this plea because you did commit the acts charged in the indictment as amended of your own free will?
Yes, I'm accepting them on my own free will.
Yeah. Are you? The indictment has been amended, but do you agree that you did what the amended indictment says you did? In other words, what
Yes, sir.
Okay. You did. Know your constitutional rights to your desire to enter a plea charges allow the court to fix your punishment. Is that correct?
Yes, sir.
Okay. Do you have an original agreement here so I can hold it up?
Yes.
Is that your signature on there, sir?
Yes.
Okay. Okay, I'll accept the plea. What are the court costs in this case?
Not really.
How much?
$222.50.
Okay, 220. I'm not gonna impose a fine. $222.50.
It is.
Yes.
Okay, now, when can you pay the $222.50?
Soon.
Well, I'll allow you to pay $50 30 days from today, or you can pay it all in advance and $50 every 30 days after that. But as soon as you pay the $222.50, you go off supervision according to the plea agreement.
That's correct.
So, I would probably want to do it. You need to go to the probation and parole office. Let him out today.
Yeah, if you live up there, he can wait for me when I get there, Your Honor. I'll head there straight after I leave here.
Okay, will you wait, or just wait around the jail, be best thing, or,
You can just go to my office and wait.
okay, we're gonna go ahead and let you out as soon as the order gets there, and you hang around and go to the probation and parole office just to get signed up. You got somebody that can meet you up there and make the $222.50, you don't have to go under supervision at all. You follow what I'm saying?
Okay, in Adair County or come?
Adair County. We're gonna
Okay.
let you out of jail in Adair County. You go to the probation and parole office up there in Adair County.
If he's gonna pay that to not be on supervision, he's providing me that receipt so I can provide it to the court.
You understand? Okay, thank you very much. Now let's bring Timothy Boggs in. Timothy Boggs.
Coming, Your Honor.
Cumberland versus Timothy Boggs, 25 CR 0021. Mr. Boggs, you previously identified as being born in 1999, is that correct?
Yes, sir.
Last four digits, social security number 4290. We're here on a pretrial conference. Is there a plea in this case?
Yes, Your Honor, it's a sentencing.
Sentencing.
There's a PSI.
You have a PSI here?
Megan brought it out for the go over.
Great. Have you had an opportunity to go over this with your client?
I did, Your Honor.
Sir, have you had an opportunity to review the precinct's investigation report done by probation and parole?
Yes, sir.
Is it substantially correct, counsel?
Yes, sir. There was only one change. I think it's on page 5. It says that in Indiana, he was found guilty but mentally ill. He said that's not correct. He entered a plea to that. There was no trial and there was no.
Well, that's finding somebody guilty. That's the terminology. If you plead, you're found guilty in one of these reports. Isn't that right, Mr. Garner?
Please, right.
Okay, it just says but mentally ill and he's made no defense about being mentally ill. I want to make sure the court understood that. If that's the terminology Indiana uses.
I don't know. I don't know.
Okay.
I don't know.
I don't know that I'm mentally ill. I didn't,
It doesn't mean that you're mentally ill.
Oh, okay.
You have entered, all of us might be mentally ill at some time. What it meant is that the time you did a plea, maybe to diminish the punishment or something like that, you reached an agreement. You see what I'm saying? So we'll
Yes.
double check what the record says up there and delete that if it's necessary. I'll tell you. There, okay, so the defendant. Let's see what it says here. The defendant shall receive a sentence of 6 years. Mr. Hunley, y'all want to watch this thing here to make sure I'm doing the right thing. You got any paper? You don't look like y'all have any paperwork on it here, do you? This report is a little different than I'm used to having. It doesn't have the same.
Timothy Boggs, you want the PSI, I'll offer to read.
What I've got here is 6 years, drug court, 60 days.
Yeah, well, the defendant shall receive a sentence of 6 years, serve 60 days home incarceration, balance probated for 5 years. Defendant shall receive credit. Defendant shall pay court costs. He shall obtain a gainful employment. Defendant agrees to have any and all other. Defendant also remains on active supervision until all court costs are paid. Doesn't say anything about drug court.
He's living in Indiana.
Has he got his 60 days in yet?
No, Your Honor. He's got, I think the PSI shows about 12 days, and then he would have 3 more since they turned themselves in on Tuesday.
Well, he's got 60 days, so You got 15 and 60 days. What are the court costs in this case?
$220.
$220. Okay, well, this is a felony plea, so we'll order a pre-sentence investigation report.
That's it, Your Honor.
Oh, it's already, yeah, it's on the docket wrong. I guess reason I keep on doing that.
Got it. If I could interrupt you, you asked me what our understanding was, and I mentioned drug court. That just must have been part of the negotiations. The actual offer was, sentence of 6 years, served 60 days home incarceration, probated for 5 years. There's nothing in the plea documents about drug court.
Right. You know, there's also nothing about him being in jail. So I guess he gets jail credit up this time and the rest of it's home incarceration, but where does he live?
He's got an Indiana address, Your Honor.
See, how do we do in-home incarceration with him being in Indiana?
It's my understanding that they can put the ankle bracelet on here and then GPS monitor. Him
I
up to
don't see,
there.
well, what if he leaves? What do we do? What if he cuts it off, or what if he cuts it off, but what if he goes somewhere else and how do we pick him up? He's not in Kentucky. This reason this is, Mr. Garner, what do you have to say?
The only stipulation that I can do to assist this is he'll be an interstate compact transfer. I can ask that the receiving state provide that 60 days on incarceration and force it up there. But I can't guarantee that they will.
No, and you also don't know how long it's gonna take for them to accept him. He's in jail here.
Well, where he'll be an immediate transfer where he is a resident of receiving state in a year. He can go straight back as long as he fills out the paperwork before he leaves. And he'll be put on a travel permit and he'll have 30 days to get that squared away.
Does it help that he's already on supervision with probation in
There'll be a
Indiana?
judicial economy too. They have a mutual interest in supervising the floor.
Well, I'm gonna say, let's let him go. You know, I mean, we can't enforce it.
How long has he been in jail here? Waiting this?
4, 5 days.
Here, about 3 days.
Okay.
And then he was held, did he get extradited?
No, sir. No, he turned himself in on Tuesday.
Turn it where?
Here, at our jail.
I got a travel permit and stuff, so, and I turned myself in.
Indiana gave him a travel permit to come down here to turn himself in.
No restitution or anything over this thing. Well, let's just put him on the probation. Just put him on the probation. 5 years, sentence of 6 years, I guess. Let's see, print it out here. Shall receive a sentence of 6 years. Probated for 5 years. What are the court costs?
$220.
You pay $220 court cost. I'm gonna put you on probation from here,
Okay.
and then they'll transfer your probation up there on judicial kind. Forget the in-home incarceration. It's not worth fooling with.
Thank you.
You understand? And I'm gonna tell you what, though. If you jaywalk, since I let this in-home incarceration go, if you jaywalk, I'm gonna revoke you. You understand what I'm saying?
Yeah.
Okay, well, so we'll get the paperwork. He can be released today and soon as he
Report with
pays
his father.
Do what?
We're having a report with his father, Your Honor, same time.
Yeah, both of them report at the same time, and you pay your $220, I'll let you out of jail.
Okay, that works. Thank you.
Okay, see.
Thank you, Judge.
Okay. Thank you.
So that concluded this most unusual session of the Cumberland.
It is unusual. I hope it included. Yes.
Okay, we'll be back at 1 o'clock. I'll be here at 1 o'clock.
We had an extra.
Yeah, come on. We'll clear the courtroom and let you.
Thank you.
No child support docket today. Logan versus McCoy. Oh, council, how are y'all doing today?
Hello, Judge. Good afternoon, Judge.
Judge, I think we just need to get a hearing date. in
What
this
we have,
case.
what's to this be decided, disputed issues, what kind of.
My client had filed a motion previously asking to be determined to be the residential custodian and to get more of an equal timeshare schedule set up between them.
My client is of course opposed to that, Judge. He has been the primary residential parent, I believe, for the past couple of years, with the children primarily residing with him. Mom not exercising city visitation, so we may need to have a hearing on those issues.
Okay. I won't say what the length that y'all would have, but would want to have, but what do you think we can do on this? How long is it gonna take?
I anticipate having a therapist testify, my client, maybe one other witness, so I don't know.
Roughly the same on our end.
2 hours?
Three, probably to be safe.
Hmm. Okay.
Don't work fast, I don't think it'll be that fast.
Yeah, I'm long-winded.
When can you have your therapist ready?
I would say it's gonna take probably the 1st of December just to get through the holidays and then get them here, because they have to have 30 days notice.
Okay.
But I don't know that, say I have 30 days.
What about our Wednesdays? I know both of you participate. You have district court on occasion. Are Wednesdays bad or good for you guys?
If I can schedule in advance, I can make arrangements on Wednesdays.
Well, it does another day better for you. How about Fridays?
Fridays work better.
We can actually, if we start in the morning, we can do the 5th, November 5th, if you like. Is that far enough out or you want a little farther out?
You do that one, Judge.
Okay.
What about the 12th? Do you have that?
12th of,
December?
I'm not available then, but the 19th.
Are you talking about November or December?
We're into December
In
now. We
December.
can go back to November if you want to.
Now, I don't know that I could get the therapist available at that
But how about November the 28th?
November the 28th. Let's do try and set us up.
When is Thanksgiving?
Thanksgiving. Black Friday.
Yeah. Well, how about November, how about November the 25th on a Tuesday?
I have circuit court that afternoon, but I could probably do it in the morning.
Let's do it in the morning. That would give you some incentive to finish by noon.
What time? 10, 9, 10?
Let's start at 9.
No.
I'll do a notice of hearing, all that.
You'd be fine.
Into this temporary order, yes, if you don't care. It's an agreed temporary order they've got, yes.
What was that, 24th? 17th,
Tuesday, the 25th.
25th?
Yes.
When it blocked over, it didn't pick up. No. Okay.
Yes.
Anderson versus Anderson. What we got here?
Judge, this is my motion to review the division of the party's marital property and to allow my client to pick up some items of personal property. We've previously tried to see if we could hash this out without court intervention. We've had a date scheduled and then we can't seem to get an agreement about allowing my client into
What
the
kind of
formal.
stuff, what are you talking about?
They've not divided up any of the personal furniture or any of the marital items of personal property at
Is
all.
there an order to that effect?
Yes.
That designates the stuff?
Well, we had agreed that they would divide those if we exchanged lists. We exchanged the list. And then there's a couple of items that one party claims is marital, the other party claims it's non-marital, or they're both claiming it's non-marital. I thought we had agreed this prior to us having the final hearing, but we're not getting anywhere. So,
Well.
and my client would just like a chance to go into the.
Give me an example of, if y'all agreed on what you don't agree on.
For the most part, I think they each one have a couple of exceptions to each other's list. The majority of the list, they're in agreement is marital. And that was my offer, was that they sort that up, because the final order had said that they would divvy it up item by item, basically like a draft, alternating items. And then once that's done, I think we're gonna have 15 or 20 items left that there might be a disagreement on. Then we can try to hammer out an agreement on that or come to the court if necessary.
Jeez.
And Judge, my client had just asked about going to the home just to look to make sure the items on her list are still there. And if she can do a walkthrough just to make sure none of it has been disposed of. We can't get an agreement on that. And I mean, I think we're at the point, we're gonna have to do a coin toss to divide things up, other than let the court take testimony and proof on their non-marital items that are in dispute.
Well, I've never done this before. I'm gonna have a hearing on every item. I'm gonna count spoons, because there's no possibility y'all gonna reach any agreement. I'll just be back here again on the same. And so, let's schedule a hearing now, and I want to complete an exhaustive list of spoons, forks, knives, anything we can't agree on. I'll divide them.
And Judge, that's one of the reasons why we were asking to be able to go into the home. My clients.
You're gonna get an opportunity. Okay. On November the 25th, I'd previously scheduled something for the morning. That morning, you won't, so that keeps you from doing that on that day. Is that
I
correct?
could,
This is gonna be like a
I
5
know.
or 6, 7, 8 hour thing. I can see that. We're gonna have to go through when they got it. I want receipts, all that kind of stuff. What about the day before that? The 24th? It's a Monday.
I'm free that day.
I'm in district court that day, but I can make arrangements to where I can do the hearing and have all my stuff in district court covered, Judge.
Okay, well, let's start at 9 a.m. That's 24th, great. It flips over, it loses those. Get this thing to operate. Yeah, I have it. Okay, now here's what's the deal. You want to examine and you and your client both will want to be present before anybody else goes in the house.
Well, we would object to her going in the
Well,
house.
she's going in the house, okay, so let's arrange it. I'm gonna give him enough time so he can, do an inventory or something, and he can arrange to, if there's anything in there that he doesn't want to be in there, when she views the thing, give him an opportunity to remove that or put it someplace else. It's not any of her business. I mean, he's got the right to privacy and stuff, that sort of thing. If they lingered around and let that stuff stay down there, so she's gonna get to do it. Now, is it gonna be necessary for me to order the sheriff or someone down there to be present? Y'all want that? Or, your council will definitely be present.
Yeah, I
Both
think if
council
we're
will be-
present, it shouldn't be an issue.
Well, I mean, if y'all want me to have the law down there, it'd be fine,
Yeah, we prefer
You want sheriff down
some
there?
representative.
Okay, well, I will get somebody in the sheriff's department, include that in an order. Now, y'all pick it that it's agreeable. That's your calendars. So the 24th is gonna be the hearing. So I would think that, just give me a date. Get your calendars together. If I don't have to be included in this calendar.
He did 14. Okay, what time?
Uh,
I'm sorry. Looking wrong. Do you want to do that morning or do you want to do that? That work for you? Okay, that'll be fine. 1 o'clock on November the 14th on Friday, Judge.
Okay, well, y'all just put it in an order, And, and I don't know how far apart that y'all are on this thing. But it's extremely difficult to divide personal property and without establishing value to them if there can't be some kind of agreement. So it could very well be that I have to determine what marital and what isn't marital property. We just have an auction and sell all the marital property. That's the fairest way, and whoever's got the longest pole can knock the apple off the tree, set everything out in the yard down there, have an auction. So I would encourage you not to do that. But
I can at least assure from our side, we'll do everything in our power to try to get it set.
I have no doubt that you will. I have no doubt, but these are personal items and it's difficult sometimes to make decisions or to reach accord, so the attorneys can't make those decisions. You encourage your clients, if they get to a situation where they feel like they're being wronged, then we'll just handle it from there. Be fair to everybody. We'll just lay it all out there and let it be auctioned. Okay?
Thank you, Judge.
Thank y'all very much.
Good, that's all.
Yeah, absolutely. Carver versus Carver.
Good afternoon, Your Honor. This is Chris Davenport. I'm on Zoom.
Good afternoon, Judge Jonathan Lanham for Mr. Carver.
Okay. What do we have here? Is it a motion to set for trial? Is discovery finished in this? Somebody doesn't have their camera on.
Yeah, Judge, that's me. It shows that it's on, but not that anyone really usually don't want to see me, but I'm not sure why it's not working.
Thank you.
Well, Clay Hunley's already gone and Mr. Lavit's not here today. They usually are the ones that set the technology up for us.
It's on my end, I believe, Your Honor. It's showing.
It's on your end because obviously technology is like top notch here.
Judge,
Okay.
I hope you're okay with me proceeding as is. Maybe you can recognize my voice, I hope.
Well, okay. What has discovery been completed?
Judge, I'll give you an update. We were before Your Honor in August, and I have received in 2 pieces additional discovery for Mr. Lanham and Mr. George. The most recent I got today. I am assuming that that is complete. I sincerely hope it is. We're kind of at the point in this case, Your Honor, that my client's going to have some dissipation claims against Mr. Carver regardless. And if there are still items and assets and transactions he has not disclosed, I'm at the point at this juncture of just adding those to my dissipation request at any rate. It's kind of the law of diminishing returns in this case, frankly.
Judge, we've provided everything that's been requested as of August. What I sent to Mr. Davenport today was just the digital version of the interrogatories that we sent several weeks ago. I got that over to Ashley today. So it's our outbound interrogatories that have not been responded to yet, and we're still waiting on the conclusion of that discovery from Mr. Davenport and Ms. Carver to proceed.
What are you owed from Ms. Carver? What kind of discovery are you owed?
Just responses on interrogatories at this point.
I mean, what are those interrogatories? Are they 2 pages, 20 pages, 50 pages? Mr. Davenport, you have those? How long do you anticipate for you to answer those?
I think it's probably about 10 pages, less than 10 pages.
Mr. Davenport, do you have those in your possession?
I'm not sure to what Mr. Lanham is referring, Your Honor. All I've gotten today so far is an email from Mr. George that provides information relating to Mr. Carver's alleged loan payments from his grandparents and information regarding the stuff we discussed in August, the $100,000 note, loan payments made to or by Sarah Turner, and ledgers of the hunting business.
Well, he claims that he has interrogatories that he has presented to you that have not been.
Yes, sir. I understand that's what Jonathan's saying. This is the first I recall being made aware of that. I'm assuming he's talking about supplemental responses.
No, not at all. I mean, we had prior to a few weeks ago, we had not actually sent out any interrogatories to propound upon Mrs. Carver at all.
Okay, so I'm sorry, Your Honor. Then I misunderstood what Jonathan was saying.
Right. You're not sent interrogatory. Wait just a second. Have you not sent interrogatory?
We did many weeks ago.
When did you send them?
It would have been September.
Well, this is October. So has it been over there a month?
I think it was the last Monday in September, the 29th, I believe.
Okay, well.
And I know that they were received because Ms. Gilbert, Mr. Davenport's associate, sent me an email confirming that receipt.
I'm not going to argue about dates, or anything. Mr. Davenport, can you check your electronic files or whatever you have to see if you received those interrogatories and give us some idea on when you can respond to?
It looks like they were received on September 29th. And the fact that Mr. Lanham has referenced Ms. Gilbert supports what my assumption would be, and that is she is working on responding to that. Of course, the responses aren't even due until sometime next week. So he would not have known her identity otherwise.
Okay. Okay, well, here's the deal. Since those interrogatories are not finished yet and are not due yet, I don't see setting this for trial. So what I'm gonna do is I'm gonna put a drop dead deadline date on this thing. We're gonna be back. I want you, by, let's say, November. Let's see, I don't wanna wait till the next rule day in case there's some disagreement. The next rule day here is November the 20th. By the 13th of November, I want y'all to file any motions if there are any discovery issues left. Okay? It's by the 13th. If all
Notice those for the 20th, Your Honor, if there are any.
If there are any problems, we'll notice them for the 20th. And if there aren't any problems, y'all won't have to wait till the 20th. I've got my calendar. And if y'all got discovery complete, we can go ahead and pick a week up toward the resolution of this thing I'll call in the office and we'll pick a date out, okay? And I anticipate this will probably be a couple of day situation. Am I
Yes,
correct?
sir. My anticipation was to probably ask for a day from Your Honor. I know the circuit does not routinely give out 2 days. And I was optimistic maybe we could do it at one, but it will be a lengthy trial.
And there's gonna be a lot of numbers and I don't want to get fogged over here too much. Now, let me ask you, because Mr. Carver is involved in some other court actions here that might have some effect on what assets are available or what he received or what he didn't receive, sort of thing. Are we gonna run into any problems there where he will not want to testify about things, Mr. Lanham?
Judge, I think he'll have to invoke the Fifth Amendment privilege.
Well, until then, I can make a good argument that until that issue is resolved, if he's gonna take the Fifth Amendment on a bunch of things in this divorce action, Mr. Davenport, it would probably not be fair to your client to proceed.
Well, Judge, of course, the court, to the extent he pleads the Fifth, cannot use that against him in his pending criminal case. But I believe the court can make any inferences from his pleading the Fifth in a civil case. So,
Well, I'm just talking about what if he comes in here and refuses to answer anything about assets or transactions or things like that. I mean, I'm not going to be able to situation just to speculate. I'm not saying he will do that. We're just
yes, I think the biggest property dispute you're going to have, Your Honor, will be over the assets that Ms. Carver will show existed that have not been accounted for either by way of where they are now or any sales proceeds that were received in exchange for those items. Those are dissipation claims. And frankly, once she shows those items are gone, it becomes Mr. Carver's burden to explain what happened. And if he pleads the Fifth on those matters, I think I don't think that prejudices her. I think it prejudices.
On dissipation claims or existing properties, I don't think the Fifth Amendment will get him there. But I just want for both of you, to understand that if we get into that situation, if there aren't any assets that you claim Mr. Carver had under his control that are involved in the other action, we won't have a problem. In other words, if you're not claiming any dissipation of assets that he received, if he did receive anything unlawfully, then I would assume that you would not claim any marital interest in unlawfully gained situation.
No, sir.
Not that he did. So I'm not saying. You follow what I'm saying?
Yes, sir.
Okay, well, we'll just go ahead and when I get back to you, I will set us a couple of days and see how we go on it. Okay, thank y'all very much.
Thank you, Judge. Have a good afternoon. Brewington versus Brewington.
Morning, Your Honor, or good afternoon.
Can you turn your camera on, Mr. Bertram, or are you and Mr. Davenport both unable to turn your cameras on? There we go. There you go. There you go. Okay, whose motion is this?
This is our motion, Your Honor. This is quite simply to allow a 9-year-old child to enroll in the public school system. She probably, prior to this, she's been homeschooled with consent of both parties. And my client's also requesting equal time sharing with that child. I think the facts are relatively undisputed, or at least the material facts are. We've got a guardian ad litem report who's interviewed all the parties and the child and all that. And I think the undisputed facts are that nobody disputes that this child wants the opportunity to try attending the public school system. And second, the child has previously been homeschooled by agreement of both parents. And 3, there's been no criticism of either party or the homeschool program that it has been implemented. And the mother and father both live a stone's throw apart in rural Cumberland County. Child's 9 years old and would ride the school bus to and from school. Now, the concerns expressed by the guardian ad litem are rather minimal. They're not specific to this particular case, but rather concerns anybody would have with a child beginning to attend public school. But I think those concerns, although they're characterized as risk, I don't think that a decision to attend the public school system is an unhealthy risk, but instead a rather healthy risk.
Okay, let me hear what Ms. Capps has to say, Ms. Capps.
Judge, the parties had 3 children together. One child was homeschooled all the way up and is now successfully enrolled in college and living, or in Cookeville, and doing well. They have another child that's an older teenager. He's also still doing well in homeschool. My client is able to produce all of the records showing the homeschool program that all 3 children have done and have excelled in. In fact, their middle child is getting Keys money. He's done so well.
So the middle child is not interested in going to public school?
According to their motion, no. And
Now
the
tell me
issue,
about the youngest child, just for a second before I let the guardian allow them to talk, okay?
and then, of course, the parties had agreed all during the course of the terms of their marriage that was how they would conduct the schooling for the
They're not
children.
married anymore. Tell me about the child.
About the youngest child?
What's-
We have concerns about the youngest child because she is being heavily influenced, because every time she visits with her father, he's constantly talking to her about going to public school, his girlfriend's children.
Okay, I'm not talking about why we'll get to that later. I'm talking about, has she reached a conclusion or expressed a desire to go to the public school?
She has expressed a
Even
desire.
if you think she's been influenced.
She has expressed that she would like to see what it's like, but she doesn't really have an idea of that. Judge.
I'm just asking what she's expressed in. You move over this way a little bit and let the guardian lie just a second. And you have interviewed the child, Madam Guardian ad litem, is that right?
Yes, Judge, I have.
Okay, and how can you enlighten me on this?
Judge, the minor child did express a willingness to want to attend public school. However,
Willingness or a desire?
she expressed a desire to attend public school. However, whenever I asked her, what was kind of the plan, should she enter into the public school system and decide that she doesn't like it, she thinks it's going to be as simple as just returning to the homeschool program, just saying, hey, mom and dad don't like it, and things are going to return to normal. I think it is very obvious.
Is that true? Is it, how hard
I
is it
have
to get
no
back
idea,
into
Judge.
homeschool?
That would be a question for,
Well, I don't, it's probably you ought to inquire, find out about that. So does the child seem to understand what's going on?
the child seems to be heavily influenced, and her words to me, I want to make sure I quote this correctly out of my report. She was more concerned of the arts and crafts, kind of the fun aspects of school. Those were the things that she continued to discuss, kind of the special classes she's going to get to attend, and doing a lot of that, as well as seeing some of the new stepchildren that she's been integrated with. Those were kind of her main focus. I'm not sure that she fully understands what the concept of public school is going to be.
She's 9.
Yes.
what would that be?
That would be fourth grade, Judge.
Going into fourth grade?
Yes.
In fourth grade.
And Judge, this child is already active in gymnastics. They go to public reading classes and things. I just want you to
I
understand,
understand. I'm just asking.
she's not been sheltered at
I
the home.
understand. I understand. I can see why any child that was in homeschool that is exposed to other children, they're doing all these supposed fun things that aren't nearly as fun when you get there as they sound like they are. It's like the grass is always greener on the other side. Have you ever heard that one, you know? So, you know, I really, I think the facts are pretty established already. I don't really think hearing any evidence on this would be good because, you know, you're gonna have people that say that the child was influenced, encouraged to do that. Of course, he's gonna say that she talked to him back, but he didn't try to influence him. So, I mean, there you go. So the issue is, as far as I'm concerned, it will need to be resolved. Is there case law where there is disagreement between parents? One parent wanting the child to go to public school and the other one not going to public school. So they have joint custody of the child, although the visitation is not equalized or that sort of thing like that, or the timeshare, rather, is a better word for it. Visitation. So I just want y'all to give me some issue and see if there's any way. Do they have some kind of transitional program for children that have been homeschooled?
They
In
have
my
to,
distant past, I remember there's a transitional program where kids can come in and see if they could acclimate or that sort of thing. And if they didn't, is there any, you don't know?
and they have to come in and do required testing. Their vaccines and things have to be up to date. That's also another issue that these parties agreed on certain aspects of vaccination with their children.
I'm not asking you to go there.
Well,
I'm asking you if you know of any transitional.
well, those are things that would
No,
have to be
those
done,
things that
Judge.
have to be accomplished before you can do it. I'm asking it, once you get your, whether you listen to Secretary Kennedy or Fauci, I don't know, whoever you listen to, that's a whole different issue. And that might be something that would prohibit them from wanting to go forward if they didn't want the child to be exposed to all these vaccines. I'm just asking if there is a program in the Cumberland County school system where homeschool children, once they meet all their criteria, if they can check it out for a month or two. I want to.
No, they don't have that, Judge.
Okay, will you inquire of the school system as guardian ad litem, right down the middle on the even thing, and give a hypothetical situation if you had a child that was inquisitive, that showed some indication that they wanted to do that. Is there any pathway for them, you know, to continue their homeschooling so they won't be interfered, but have visitations or go there and see how they would acclimate for a few days? I don't know. Maybe we start a new program.
Your Honor, for what it's worth, we had proposed that this not start immediately, but that the child would start in January for the second semester of school, and that the in-between time be used for a transition period to see what was available to assist in the process.
Well, I'm going to first have to decide who has the authority to make the decision on whether, and if there is an impasse, whether there's a preference given by a lot of public education or homeschool. I don't know the answer to that question. I know that the homeschool people have been very successful over the last decade or so to make changes in the law to assure that more control. I don't know if it's gone that far. And whether they're going to be, I'm going to have to do a Solomon bit here or not. I always prefer not to do Solomon bit because every once in a while, nobody stops and the baby gets cut in two, you know. So we'll take a look at that. And now, do you think that does child receive any counseling or anything right now of any kind?
No, I'm not aware of any.
Nurturing parent, she's done nurturing parent classes with Miss Lawson, Judge.
Yeah. Well, at some juncture, it might be necessary to have the child interviewed by some neutral party, some child psychologist or something, to see what the motivation is. Maybe someone that has experience addressing children at that age, that has expertise, to see what the motivation is, and that she could really be would both sides be interested in maybe trying to find
My
somebody
client
like
would agree.
that, maybe to see where we're going?
I have one, Your Honor, that can do that kind of thing, but I just want to express, for what it's worth, my observation and speaking with my client. I think this boils down to this child's very well adjusted, does well.
I mean, that's what you say, and I have no reason to believe that your client doesn't believe that, or that you aren't being honest. I have no reason to believe that, but the other side says not so.
Okay. What I'm trying to say is that she's been I think my understanding is she has been exposed to a lot of stepchildren who are.
What I'm saying is, I don't want money on this now. I mean, I know you believe what you're saying and that sort of thing. You're an experienced practitioner and you know how things gonna go. But I want us to find somebody to talk to this child, somebody neutral. I don't want to do anything intrusive. You know, homeschooling is either wonderful or awful. If you've got people intense and they've got the right curriculum and that sort of thing, but there are attending deficiencies sometimes in the social development of children that are homeschooled. They're protected from a lot of times, but sometimes if you protect children too much and they get exposed to it all at once, they can have a crash too. You know, I mean, I'd ask the guardian ad litem to help find someone that's agreeable to both parties so y'all can go back and forth. And thank you for all being reasonable. I mean, child is blessed with two parents at least that are still interested and want to do something for the benefit of the child, even if they're in disagreement on it. For that, the child is blessed, and I wish everybody had two parents that were so interested. Thank y'all very much, and I'll just wait till we hear back, and I'll get it on the docket just as soon as we can once we get somebody scheduled to talk to her. I'd like a status quo ordered, since one party believes that the child is being influenced, not to be talking to the child about that, not to try to influence the child, either party, not to try to influence the child. Just tell them that y'all are trying to work through it. Everybody loves the child. You're trying to work through it and try to get somebody to talk to her to help her go through her decisions. Okay. Thank y'all very much.
Good.
Okay, River Valley versus Brandon.
Good afternoon, Judge.
Hello.
Sorry, I can't see in your courtroom to see if Mr. Hurt has come to the podium yet.
We got a voice activated microphone.
Okay, there you are.
There you go.
I'm here.
Yeah.
Judge, Ms. Wiggins and I had a deposition. I don't think there's anything before the court today. I think it was just on for review. And we had indicated the last time that we were in court that I think there were some depositions. We did conclude those. I got I think a copy of them maybe last week. And I think last night or early this morning, I got a motion from Ms. Wiggins, maybe a motion for summary judgment. I've not obviously had a chance to review it yet, but I think it was noticed for November.
That is correct.
Will you file your response to that?
I'll
And we'll
file a
see y'all on November 20th.
Thank you, Judge.
Thank you, Judge.
I can't send you a roadmap on how you get down here, you know, if you want to come personally. We always, you know, kind of makes us look like we're having court, have all you important out of town lawyers come up here.
Understand that. Trying to avoid that, Your Honor. Thank you.
Okay, take it easily. Carney versus McCoy, Carney and others versus McCoy.
Judge,
Yeah. Hey, what do you have?
this was an action I filed, declaratory action I filed based upon some deeds that were.
You need to
convicted.
speak up a little bit. I'm sorry.
This was a declaratory action I had filed on behalf of the plaintiffs, where their parents, or their mother had deeded to the plaintiffs as well as the defendant Charles McCoy property. And part of that deed, it conveys the property to Charles in trust and names two of the sisters as trustees. The deed does give them the power to sell it, but we filed this declaratory action just to avoid any type of problems. They do have a potential buyer. So what we're asking for, Charles was served, and then we were concerned also about Charles's mental capacity. So we had a guardian appointed for him. I don't think the report's ever been filed by the guardian, but.
Well, I mean, I have personal knowledge of the fact that Charles had a couple of trials for his competency and he got the long-standing record. He won both of them, I think.
Yeah, yeah. So there's
He's the only person I know that's got his papers that he's competent by 2 jury trials, so.
well, he's been served and he's now in default, Judge. He'll
Okay, we
serve
kind of
his-
slide over here and let the guardian, she hadn't filed a report. Have you had an opportunity to interview Mr. McCoy?
No, Judge, I have not. I've had extreme difficulty reaching Mr. McCoy. If someone can point me in the direction of how to speak with him, where he's at, where he's located, I would be glad to do that.
He's at his home. He doesn't like to cooperate. That's too much. So,
Really?
yeah. You probably know that.
I'm just.
So I don't have.
It's very difficult, some of the founding fathers said that our Constitution was meant to govern people who wanted to be governed. They didn't use other expression. And if you get people that don't want to be governed, it's very hard to govern them, if they don't participate. But nobody's filed an answer for him.
Correct.
Yeah.
Nobody's filed an answer. And, with the court's comments, I'm not sure it was necessary to have a guardian. We just did that out of precaution.
Well, I understand. It is a precaution. But I don't know. Those were moments in time where he was competent. Moments in time. I don't know what his status is now.
He's not been found incompetent, so.
Well, no.
But we'll proceed ever how we can wait till the guardian speaks to him. He's at home.
Well, I'm gonna give, I don't know I'm not so sure that if somebody goes down there, that somebody ought to go with you. I don't think I would go, I'm not reflective on your ability to defend yourself or anything. I would just want to witness whoever you were. I'm not.
Yes.
Yeah.
I'm on that same page, Judge.
Okay, well, if you want me to, if you could get a hold of the sheriff's department and see if they'll accompany you there. If they will not accompany you, I will appoint a special bailiff, which I haven't had to do anywhere, but I can do a special bailiff to accompany you down there and try to get a report back, and then we will, I really have no reason not to enter the summary judgment. I wonder why you didn't do it. He didn't answer, did he?
He did not answer. I filed motions for default / summary.
Yeah, I see. It just
I
saw,
did it
yeah,
both ways.
yeah. Yeah.
So I did ask for.
I just
default
think,
as well.
I think we could avoid some major problems if somebody goes down there and talks to him and explain to him that the time for him to file an answer has passed, and just see what kind of reaction you get there and to give a report back, and maybe to see if it's necessary to have some hearing on his competency.
I know the sisters there are 2 of the sisters are here. They go to his home, check on him regularly and make sure he's doing okay. So, but if you just have law enforcement versus the family there, that's okay.
Well, they're the plaintiffs.
They are the plaintiffs.
So, I wouldn't want them to put them in a situation where the plaintiffs have to go down there and determine someone is competent to.
Yeah, no, I'm not asking that. I'm just talking about for the peace, to maintain peace.
I don't think there's gonna be a lack of peace down there. I want somebody to witness the fact that the discussion took place, and because we might not be able to get him up here unless I send the authorities down there to bring him up here, and that would probably not be pleasant for anyone and would be disruptive to him and upset him. And, I just like for the guardian to go down there and just have you ever talked to this young man in your life?
Yes, Judge. I have been appointed as his guardian and guide him through his numerous cases he's had in the criminal court, and he is always very open to talk to me. I have known Mr. McCoy actually my whole life. If someone can just get me in front of him, I think he would gladly speak with me.
Yeah.
It's just the getting in touch with him.
And get her directions.
Yeah.
Well,
Okay.
I know where he lives,
Oh,
but
well, that's
it's
where he's
just
at.
taking somebody with me.
Okay. Well, Mr. Bailey, go down there, won't you, Mr. Bailey?
I went to high school with Charlie.
I think he'd be a good person to
We're
go.
taking a road trip.
Will you get permission from the sheriff for you to do this? Because, okay, I think that, I knew that y'all were about the same age, and I think that would be less threatening than someone that he didn't know. Right? And then once we get that report, you don't have to wait for the next rule day. see what she has to say and we'll just put it in the record and move on,
Right,
okay?
I've tendered a judgment.
I know.
Okay, all right, thank you,
Okay,
Judge.
thank you very much. Carmen versus Warner. For review, Carmen versus Warner. What do we have here?
Your Honor, I was appointed as guardian ad litem for the child. I think Travis Bell is counsel for the plaintiff.
Did you interview the minor child?
I have, Your Honor.
Okay. And what's the issue that we have left to be decided?
Well, I'm not really sure where we're at this point, other than my response is pretty much the same that I said last time. I haven't done anything to interfere with the custody order. It's simply my daughter does not feel comfortable being around her father at this time, and
Okay, what did
she's
you?
made that very clear.
Okay, how old is the child again?
16.
She's just turned 16, I believe.
16. Well, they're easy to deal with. You just tell them immediately.
I wish I had the magic.
Yeah. What did you find out?
She has, she's very firm in that she does not feel comfortable around her father for not only physically, but emotionally.
Where is the father today?
I don't know. That's Mr. Bell's client.
Is Mr. Bell online?
Yes. No, it's not.
If he's not here, I don't see how we can proceed, so. If you filed a written report,
I did, Your Honor.
okay, I'll look at the report. And what your recommendation is,
My recommendation is that she not be forced to visit with her father, that she be allowed to contact him at her own pace. I have also suggested to the mother to re-enroll her in counseling. She was previously seeing someone with community-based interventions in Albany, and I hope
okay,
that
well,
she's.
there's not gonna be any change in this, and we'll reschedule it. If you'll get a hold of Mr. Bell, okay, let's reschedule it for a status on November the 20th.
I will not be available on that date, Your Honor. I have to.
Well, you filed a report already.
I
I'm just asking you to contact him since, since the other party is not represented by counsel. I would like for you to send a notice that it will be rescheduled for that date since he was not present, okay?
At 1:15.
1:15 would be fine. You need to be present here also.
I can be reached by cell phone if y'all need me that day, though.
Yeah.
I was gonna
Can
go
you
to.
Zoom from your cell phone?
I don't really know how to do that. I will be.
This is a great opportunity if you enter the brave new world. So you can, between now and then, you can learn how to Zoom, and we have a lot of people that Zoom from their cars all the time here. Okay? Thank y'all very much. We don't have your report.
I got the motion. Oh, I think I emailed that maybe to Megan. I didn't know it had some sensitive things in it. That's why I didn't e-file it, but I'll get it copied to you.
Well, you can e-file it and direct it, and they can protect it. Document when it gets here.
Well, she e-files it, it'll be in court.
Okay, well, just fax or text.
She could email it first.
Come over here and get her email address off.
I've got it, and I think I sent it to Megan already.
Okay, thank you very much. Thrasher versus Webb.
Judge, if we could pass that to next month, I think we may have a resolution to the issue at the moment. So we could just pass it to November day.
Always good to have a resolution. Okay, thank you.
You want this order in?
Yes, that's all.
Vanderpool versus Vanderpool. Okay.
And Judge, this is my motion to have, a hearing date scheduled. I've talked with Ms. Perigin. I'm sure the court's familiar with Ms. Kim Hargis, Judge Murphy's court-ordered mediator. She is agreeable if you are to come down and try to mediate this case. So we had asked her to give us some dates to try to get it pretty quickly on the calendar.
Judge, we are agreeable at this time. The only request we would have is for the court to please provide some clarity in the parents working together regarding Ms. Vanderpool's work schedule, that she may be a few minutes late, early, et cetera, given the table's work schedule, and for the father to please help abide by that and not be so stick on the 4:30 exactly, given this is a factory job.
Judge, my client has tried to work with her. The issue is, it's basically that saying, give an inch, try to take a mile. She's constantly trying to change up the meeting place, even though we agreed that the meeting place would be at
And the meeting
911.
place won't be changed, but I'm gonna do a 20-minute leeway on the thing. Okay? If there's anything more than 20 minutes, you need to call him. You tell him. And in no circumstance, how long is the period of visitation for?
Judge, we tried to get as close to 50-50 as we could the last time we were here. However, it is not becoming a true.
I don't want to argue the case. I'm just asking right now how much the visitation is. Is it
Where-
close to 50-50? How frequently do they change?
They are alternating every other weekends. It is the throughout the week scheduling that is the problem. Mr. Vanderpool is unemployed, so he's getting to keep the children essentially.
Well, I don't want to argue a case. I'm just saying, the time periods where she's late and that sort of thing. How frequently is that being? And what?
Almost every time,
Yeah, well, here's
Judge.
the thing about it is, if she calls him and can't be there at the location, it's not an inconvenience if she resets the time. But I don't want her to wait till he's already traveled over there to reset the time. In other words, let's have a 30-minute window if they reschedule the time. That way, this gentleman will not have to come and wait somewhere for a while. He can just wait to come later. In other words, if she's gonna be 30 minutes late, and, or within 30 minutes of the time, you need to call him and tell him that you're gonna be an hour late or 2 hours late or whatever, and then you can make the exchange. That makes sense?
Yes, Judge, and we would ask that if she is called off of work that day, could she start picking them up in the mornings instead of having to wait till 4:30? Some days her department is dismissed by 7 a.m. that morning,
Well,
and she has that day
y'all in
free.
agreement with that?
Well, Judge, that's the issue, is we can't get continuity because it's constant. I mean, he can't.
Yeah, I mean, it's unfortunate. She's out there having to work and.
He
make
does have a
these
job,
decisions.
though,
I
Judge.
said she's having to work at this. I didn't say anything about your client. She's out there having to work at a place that is known for moving the people around. I mean, they just do that. Maybe the chickens don't appear that day. The lucky chickens get caught in this, in a stop sign somewhere and don't make it over there in time. So. Now, your client has a work schedule somewhere? Where is he working at?
He is working a schedule around the children. He is working for, is it Shutters Automotive Repair? And I've got a statement from his employer.
Well, that's good. I'm glad he's able to work it in. So, I mean, this is something we have to accommodate. You want a hearing on the whole thing now, or are we close enough that you could think you could reach a resolution? What's gonna be mediated?
Well, here's the problem, Judge. We reach an agreement in court on the record. We stated all the terms the last time. When it came to putting it down, then we start trying to change because our clients then are not in agreement when they're not in front of you. So I think we're gonna have to mediate the final outcome of the timeshare, and we are gonna have to.
When we dictated the agreement last time, okay, did you set that down to paper?
We did.
Okay, and y'all agreed it, what it was set down to, but your
And we
clients
stated on the
wouldn't-
record that we agreed.
Okay. Well, that's what we're gonna do. The only deviation that we're gonna make of it right now is that different notice situation where if she's late or something, that she can give notice and he'll cooperate. Does that sound fair to you?
Yes, Judge, and what about the issue of if her work schedule is called off early that morning, can she pick up her children?
I think that's a fair.
It should have, I had that before, was she didn't have transportation, she wanted to pick up the meeting spot at a stroke.
Judge, the issue, he said, is that when she would be off from work. She doesn't have transportation because her mother's coming from Tompkinsville to pick her up.
That's her
And she-
problem. And I
But
just-
she offered to pick the children up in a stroller, and we're talking about children that are too big for a stroller at this point, pretty much.
She'll have to comply with all the traffic laws.
I mean, we're not talking a great walking distance.
Make sure you put that in there to assuage this kind of fear. So we got a judgment here now, okay? She gets that extra latitude to call him at least 30 minutes to change pickup time and place. And then when she gets off early, she needs to call him, but it would be her responsibility to have the children picked up, not his responsibility to deliver if she gets them early. Okay? Okay, well, thank y'all very much, and I'm telling both of you, now that this is agreeable to you, right?
Yes, sir.
Okay, and this is agreeable to you.
And Judge, just to clarify, you are okay with Ms. Hargis mediating the case? She's the,
What's there to mediate if we reach this agreement?
I think
Judge,
a final resolution.
Yeah, I think there is going to either have to be a final hearing or maybe
On
a
what? I'm
final.
trying to get y'all to tell me on what are we gonna have a hearing?
I believe on the time sharing arrangement itself, Judge,
Is a permanent order.
yes, there's
Well,
some
what
issues
is
there.
it that you don't agree to about the time? What is the timeshare now? How much?
My client is not feeling as if she is getting.
Well, I don't know. I don't care how she feels. Just tell me what it is.
The numbers are not working that she's getting a true 50-50.
Okay. Well, how much off is she? 49, 47?
No, Judge, I would say because of her working schedule and Mr. Vanderpool getting to keep the children during the day while she's at work, it's more in the 30s. She's missing out on quite a bit of time while he gets to stay home and essentially keep the kids because we presented.
Well, I don't want to get into the reasons. I know the reasons. How would you propose that she get closer to 50?
We proposed it by allowing an integration schedule with the daycare over and all.
But that's the issue,
Works
Judge.
with the Cable's factory as far as for her to drop them off on her time, pick them up. These parties are not having to interact and further escalate their problems. And
This
that was
cannot be
denied.
mediated.
That's not her getting more parenting time. That's her taking time away from him with the children so she can put them in daycare. Judge.
That makes sense to me.
Judge, it's almost as if it's an incentive for Mr. Vanderpool not to work a public job so that he can stay home. and
It's
spend
not
most of
in
the
her
time with the
business
kids.
whether, don't say anything. I'm not letting either of the parties say anything. If she has the children, it's a normal practice that if one of the other parents has some kind of conflict with work schedule or something, that the other parent gets first option on to have the child. So you're asking to say if she has a work situation, then her first option would be to place the child in daycare rather than him receive the visitation during that, or the time during that. I keep on saying visitation, it's an antiquated sort of thing. So you're saying that if she has to work or something, she go to put the child in childcare rather than him to get that time. And as far as incentive is concerned for him to not work, that's no longer her concern. You know? So if y'all want to have a hearing on this, this will not be mediated and successfully. We've already had agreements that they want to agree to or sign. I want you to give me an order that reflects what I said today, and let's have a hearing date on this. I'll make this date that you're already gonna be down here.
On the 24th.
Are you available the 24th to put on proof as far as a permanent resolution of this thing?
The 25th, is that?
I'm the 25th. Yeah, I'm sorry. I got the 24th on the other hearing.
Look at that.
Judge is trying to make sure I am definitely ready for a few days off for holiday that week.
Why should you get a day off?
I can schedule it in on the 25th. We can do multiple hearings that day.
Yeah,
Okay.
let's see. That November the 25th.
Yes, Judge.
Let's do multiple hearing. That'll be hearing day. I've got two hearings, 24th and 25th.
Okay.
Okay, well, thank y'all very much.
I guess 10
And
and
I will tell both of you, y'all need to do some prayerful consideration. Talk to your attorneys. about what the deal is, okay? Nobody ever gets this now. And, you know, and I understand your reticence because I remember when this thing first came down here, it started off pretty rough as far as the way this lady was treated, in my opinion. Not saying your client did it. It just started off rough. But I want you to be assured that you will be treated fairly. Okay, and I want you to be assured that I don't know either one of you. So you'll be treated fairly. So now we're knowing that you'll be treated fairly doesn't mean that you ought to hold out and not listen to your attorneys on what they feel like is a good settlement. You're not gonna get, neither one of you will get 100% of what you want. And a good agreement's better than, you know, throwing it out, and not knowing what happens and leave here thinking that you've been mistreated. Okay? Thank y'all very much.
Thank you, sir.
But what time is those ones good?
It started at 9. You want to set it for 1?
Noon.
Well, noon, you know, some people have lunch, and I'm not one of them, but
I didn't think you were a lunch guy.
I'm not a lunch guy. Let's set it at noon, just in case that we get finished with the other.
Judge, I'm gonna have at least a 30-minute break just to get my mind
I'll
together.
bring some nabs.
Okay.
That's what my mom used to call a little cheese cracker. It's called.
I don't want my client to have
And I
an,
think it was because Nabisco was the only company that made them, and they called them nabs. Okay, thank y'all very much. Davis versus Pitcock, is that next? Davis versus Pitcock. Okay, it's a status hearing.
Yes, Judge. Last time we were before you, we had a hearing. Wherein the court bifurcated the proof. We took part.
The issue was whether or not under the statute it had to be continuous or not. Was that it?
Potentially, I think the hearing was confined to.
I know
their
what it was. That's the
Continuous
issue that
versus
bothered me.
aggregate with the tolling period.
Do what?
It was the continuous versus aggregate issue with the
Yeah,
coupling of
that's
the
the only thing
tolling
that bothered
period.
me. You know, I think that your client's established. If it didn't have to be continuous, they're in pretty good shape. If it's aggregate, they're in good shape, you know, on the thing. What, did you find any case law?
My tolling, yes, Judge, the brief I submitted on the tolling issue seems to negate their continuous or aggregate time period, however you calculate it, due to the tolling of the statute, which was commenced by the juvenile action. They do not meet the required time period.
That's just not the case, Judge. The case law's been decided by the respondent. It's just not germane to what we got going on here.
It's
What
absolutely
tolling?
germane.
Wait,
It's a case on point.
wait. What tolling are you talking about?
We are talking about the tolling of the statute.
What tolls
or
it?
The statutory time period
What
for de
tolls it?
facto.
What tolls it?
The commencement of let me find the statute. It talks about regaining a child through a custody action. And
Well, that talks about if the party tried to initiate something to regain.
that's
and-
right. And
and-
I believe it's the Meanders, Middleton, or the Granger case. One addresses that issue in point and says the mere participation of the mother within the juvenile court action is sufficient to meet that burden.
Judge, that's just simply not the case. It
You got
does
the
not
case
cite
with
that.
you? You got the case with you?
Yeah, and the case that was cited by the respondent in her reply brief was actually the Meanders court citing a dissent from a prior opinion. Just to add some context to their opinion, it was dicta at best, but again.
Garvin v. Krieger directly addresses the source of custody and the tolling of the statute regarding a parent's involvement in a district court juvenile action. Garvin expresses that the respondent's participation alone to regain the care, custody, and control of their minor children meets the burden to toll the statutory time period.
In both cases, there had been a separate action filed, both Krieger and Meanders. Again, Judge, we've got case law that we've cited in our brief, and we would be fine letting this court decide the merits of the issue based on the briefs.
Okay, y'all gonna submit them on the briefs.
We've already submitted briefs.
So you want me to, you want to submit, you don't want any other testimonies, what I'm asking, you don't want.
There's
anything else.
no further testimony needed from our end.
So you're ready for me to decide based on what I previously heard in the briefs?
Yes, Judge, that will be fine. I've submitted my brief and my reply brief. I don't think Mr. Wilkerson has replied to my main brief. I
It
think
says
he's
he
only.
doesn't need anything else.
Judge, I haven't made a motion to file a reply. But if there's nothing really to be addressed, we're pretty clear in our
Okay,
response.
well,
That's fine.
it'll stand submitted and we'll get you an opinion. Okay. That completes civil docket. That completes the civil docket. We've got, is it 2 yet? 2, we have a DVO docket. DVO docket. Fitzer versus Pritzker. Pritzker versus Pritzker. You Teresa Ann, are you?
Yes, I am.
Okay. Where is Jack Randall?
He's not here.
Has he been served? Is this a initial finding or continuation?
It was continuing from last month because he hadn't been served. He was served October the 10th by Sheriff Williams, looks like.
Okay. Okay. Some of these things happen down in Tennessee, is that correct?
Yes, and I don't know if that report is attached. I have the card and the number. I forgot to bring it from home because I do have a copy of it. But that was on September 6th for the stalking. It was caught on camera.
Yeah, I'm just asking you, some of this happened
Yeah,
in Tennessee.
that's it.
What sort of protection you want? There's not an order, is there an order in place in Tennessee?
No,
So you don't have any kind of protection order at all?
not in Tennessee.
In Kentucky, you have one?
Yes.
I don't see it in here.
He's on the emergency.
Yeah, it is, but I'm talking about, I asked if there's any other ones besides this one, so, okay, we did an EPO.
Yes.
Well, I don't see a reason not to convert the EPO. He didn't show up, he's been served. What kind of limitations would you like on him?
I
know it would be like Mars if you do it, but it's not.
I just want him to leave me alone and stay away.
What is the present order, 150 feet or 500 feet?
Right now, he's residing on the property next door. My neighbors, till supposedly he buys a house here somewhere, so.
Has he violated the previous order?
No.
Just continue to put that order in place as a permanent violence order for 2 years. Okay? You have a signed sworn affidavit. I'll just ask you to raise your right hand. You solemnly swear or affirm that you will truthfully testify in this case.
Yes.
Yeah, I've read your petition and the statements that you lower your hand, your statements, petitions there, and all of those are true as far as these statements, threats he made about choking you and the other things are true, correct, that are in that affidavit. You're saying so under penalty of perjury, is that correct?
Yes.
Okay. We'll go ahead and enter it.
Okay. I also I'm not sure, he was served divorce paperwork, so I guess if he signs
I
them,
don't
then
know
he
about
brings
the
them in.
divorce. We're just on the EPO. He was served with the
Okay.
EPO. I don't know anything about the
Okay.
divorce.
All
Okay?
right. Thank you.
Thank
Do I
you
get
very-
a copy or do I?
No, it wouldn't do any good if you didn't have a copy, would it? But you won't
Yeah,
get it
I
right
guess
now.
so.
They'll have to be drawn up. I can sign it. It'll be probably
Next week.
about no, it'll probably be sometime today. I can get you a copy of it. Okay, so you enjoy the safety of the courthouse until then. We'll get you a copy of it today.
Okay.
Okay.
So you want me to wait?
I don't care if you want a copy of it. You'll have to wait.
Yeah.
Okay.
Okay.
Okay, thank you.